Remember that we are in the presence of the Lord. Almighty God, source of all wisdom and truth, we come before you today in humility and hope. As we begin this hearing on suffrage, we ask for your guidance. Grant us clarity of mind, honesty of heart, and fairness in judgment. Remind us that the right to vote is not merely a political mechanism, but an expression of human dignity, equality, and freedom. Give us the courage to listen more than we speak, the humility to learn from one another, and the wisdom to craft policies that strengthen democracy and deepen public trust in our institutions. May this hearing be marked by respect, reason, and good faith. And may every decision we make move us closer to a society where every citizen truly counts. Amen.
Amen.
The COMSEC is requested to call the roll of members. The roll, is there a second? It has been seconded. The motion is approved. With the indulgence of the members, may we now hear the Speaker of the House of Representatives, Honorable, I'm sorry. Sorry about that. Please, COMSEC, please acknowledge the members present, including our guests today.
Good morning, everyone. For today's meeting, we would like to acknowledge the presence of our honorable members. We have the Honorable House Speaker, Speaker Faustino Boji D. III, House Members Mula Dada Kiram, Deputy Speaker Yasser Alonto Balindong, Deputy Speaker Janet Garin, Congressman Francisco Lalo Matugas, our Committee Vice Chairperson, Congressman Maximo Dalog Jr., Committee Vice Chairperson. Our committee member, Congressman Rufus Rodriguez. Committee member, Congressman Jonathan Clement Abalos. Senior Deputy Minority Leader, Congressman Edgar Erice Jr. Assistant Deputy Majority Leader, Congressman Mark Anthony Santos. Assistant Deputy Majority Leader and member of the committee, Congresswoman Isabel Maria Zamora. Deputy Minority Leader, Congresswoman Kakabagao. Assistant Deputy Majority Leader and committee member, Congressman Ryan Recto. Assistant Deputy Minority Leader, Congresswoman Rene Luis Co. Assistant Deputy Minority Leader, Congressman Jose Manuel Tadeo Shell Jokno. Congressman Mauricio Dumogan. Deputy Minority Leader, Congressman Antonio Tino. Deputy Minority Leader, Congressman Percival Percy Sendanya. Committee Member, Congressman Attorney Miro Kimbo. House Member, Congressman Jan Franz Almario Chan. That's all for our members. For our resource persons, we have from the Commission on Elections, Chairperson George Erwin Garcia. Also Commissioner Noli Pipo from the Commission on Elections. From the Commission on Elections, Law Department, we have Director Albert Leonard Rodriguez. From the Integrated Bar of the Philippines, Attorney Alan G. Panodong. From Legal Network for Truthful Elections, we have Attorney Rona Caritos. From Bayan Muna Party List, we have Attorney Nery Colmenares. From the Institute of Government and Law Reform, Attorney Lee Edson Garcia. Also from the Institute of Government and Law Reform, we have Attorney Marie Catherine Alcantara. From the UP National College of Public Administration and Governance, we have Professor Michelle Castillo. We also invited the authors of The Political Dynasties and Poverty. We have Dr. David B. Yap. For our members, we would like to acknowledge the following. We have Congresswoman Sarah Jane Elago, Congressman Rolando Valeriano, Congressman Roman Romulo. We would like to inform the body that the following were invited for this meeting, but we don't have the attendance yet, but just in case, we have the Philippine Bar Association. We also invited PhilConsa. We invited Chief Justice Reynato Puno to be represented by Attorney Dionisio Donato Garciano. Okay. Former Supreme Court Justices, Chief Justice Artemio Panganiban, Justice Antonio Carpio, Justice Adolfo Azcuna. We have the 1986 Constitutional Commission Commissioners, Attorney Christian Monsod, Dr. Wilfredo Villacorta. We have invited the following deans of the universities: UP College of Law, DLSU School of Law, UST Faculty of Civil Law, San Beda Graduate School of Law, San Sebastian College of Law, okay. St. Louis University School of Law, University of San Carlos School of Law, Mindanao State University College of Law, Ateneo de Manila School of Law. Okay, so we have the representatives from the UP National College of Public Administration and Governance. Okay. Gosh. The La Salle University Political Science Department, Dr. Julio Tehanqui, Professor Tehanqui, confirmed his attendance. Is he here? And of course, the UP Law Center Institute of Government and Law Reform. We invited them, of course. That's my alma mater. Okay. Okay, sir. We also invited the Ateneo School of Government, Dean Jennifer Oreta. Additional members, we have the Honorable Laila De Lima. Welcome po.
We will be expecting more.
We are expecting that they'll be sending their representatives. So, with the indulgence of the members, would like to recognize Speaker Faustino Boji D. III for his remarks. Sir.
Thank you. Committee Chair, Representative Zia Alonto Adyong, and colleagues from the House, my fellow public servants, distinguished resource persons, mga kababayan, magandang umaga po sa ating lahat. Marami pong salamat sa inyong pagdalo at sa pagbabahagi ng inyong malalim na karunungan at mahalagang karanasan. Isang malaking karangalan para sa kapulungan ng marinig ang tinig ng mga taong buong buhay na naglingkod sa batas, sa katarungan at sa pagtataguyod ng hustisya sa ating bayan. Sa panukalang Anti-Political Dynasty Bill ay matagal nang hinihintay ng sambayanang Pilipino. It has been close to 40 years since our Constitution was ratified with a provision intended to guarantee equal access to opportunities for public service and prohibit political dynasties. Ngunit kulang po ito ng isang enabling law at ito na po ang nais nating ipasa sa 20th Congress. Ang Anti-Political Dynasty Bill ay usaping matagal nang tinatalakay. Ngunit ngayon ay malinaw ang aming hangarin na seryosong talakayin ito ng kapulungan ng buo, tapat at may malasakit sa bayan at sa kinabukasan ng ating pong bansa. Panahon ng pag-usapan ng gusto para makapasa tayo ng isang panukala na katanggap-tanggap ng ating mga kababayan at ng ating mga kapwa lingkod bayan. Tandaan po natin, simula pa lamang ito ng mas malawak na reformang layuning palakasin ang ating pong demokrasya. Palawakin ang patas na pagkakataon sa paglilingkod bayan at ibalik ang tiwala ng taong bayan sa ating pong institusyon. The President himself recognizes that it is time to pass these measures. Sa huling ledak, isinama po niya ang Anti-Political Dynasty Act sa mga priority measures. In light of this, together with Majority Leader Sandro Marcos, I filed House Bill 6771, which is one of the measures we are tackling today. Kaya po tayo nagsasagawa ng mga pagdinig na tulad nito upang marinig ang lahat sa panig at iba't ibang mga pananaw at ang buong saklaw na magiging implikasyon ng panukalang batas. Nandito po kami hindi lamang upang magsalita, kundi sa lahat upang makinig. Bukas ang aming isipan at bukas din po ang aming kalooban sa makabuluhan at tapat na pag-uusap. Huwag po nating isara ang ating isipin. Huwag tayong magpakulang sa mga nakapirming paninindigan. Layunin ng pagdidig na ito ay maglinaw, magtimbang, at magpalalim ng pangunawa upang magabayan ng wasto ang mga mambabatas sa kanilang magiging pasya. Marami pong salamat sa inyong lahat at inaasahan natin ang isang tapat at makabuluhang talakayan na tunay na magsisilbi ng kapakanan ng ating pong sambayanan. Marami pong salamat ulit.
Thank you very much, Speaker, for your inspiring remarks. We'd like to, on behalf of the committee, would like to extend our gratitude and thanks to you for joining us here today, for personally seeing that this measure would push through, in the committee level. And thank you very much for your presence, sir. So, with the permission of the committee, I would like to move for a few minutes suspension. Committee hearing suspended.
Thank you.
Hearing resumed. Comsec, please, we proceed with the, do you have other members? Yes, please.
We recognize the presence of Congressman Solomon Chungalao and Congressman Nathaniel Oducado.
Thank you, Comsec. Now we move to the next agenda, which is the approval of the minutes of the previous meeting. Copies of the draft minutes of the previous meeting held on December 9, 2025 have been sent to your respective email addresses. So do I hear any motion to suspend the reading of the minutes of the previous meeting and consider the same approved? Yes, Congressman Dalog.
Move to dispense with the reading of the minutes and approval of the same.
So there's a motion that the reading of the previous meeting be suspended and the same would be approved. It's been seconded. The motion is approved. Again, ladies and gentlemen, with the indulgence of the members, I'd like to address this committee in my, I'll be delivering my opening remarks. Yeah, do you have other? Yes, please.
We'd like to recognize the presence of Congressman Alfredo Garbin Jr.
Thank you. Bismillahirrahmanirrahim. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Distinguished colleagues, esteemed guests, and fellow Filipinos, magandang umaga po sa ating lahat. This is a historic day because we know that not only do the members present here today and other guests watching, but we know that the entire Filipino nation is actually watching us here today. So this is a historic day for the 20th Congress. For decades, the constitutional provision on political dynasties has existed as a promise, waiting to be fulfilled. Today, for the first time in a serious and deliberate way, the House of Representatives takes a decisive step toward giving life to that promise. Let me state clearly at the outset, this hearing is convened not to attack families, not to single out individuals, and not to rewrite political history. We are here because the Constitution commands us to act, and because the Filipino people expect us to act. We are public servants first. As chairperson of this committee, my role is not to dictate outcomes, but to shepherd this process fairly, carefully, and faithfully. My duty is to facilitate a discussion where the will of the people, as expressed through their representatives and grounded in the Constitution, will ultimately guide our work. And the will of the people is clear. This measure has expressed support of the President of the Republic, the Speaker of the House of Representatives, and the Majority Leader. It is a priority measure under the Legislative Executive Development Advisory Council. More importantly, credible surveys consistently show that a majority of Filipinos, more than half of our people, want this reform enacted. When the President, the leadership of the House, and the people themselves converge on a reform, it is not only an opportunity, it is a duty. At the same time, we must acknowledge that this is a sensitive subject. This bill touches deeply rooted political structures. It raises serious constitutional questions. Madami-dami pong constitutional landmines na kailangan po nating i-navigate. That is why we begin where we must always begin, with the Constitution. The basis for the prohibition against political dynasties is found in Article 2, State Policies, Section 26 of the 1987 Constitution, which provides that the state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law. This provision has two distinct but inseparable parts. First, it is a command to the state to guarantee equal access to opportunities for public service. Second, it provides one method to achieve that command by prohibiting political dynasties as may be defined by law. These are not framed as individual rights. They are directives to the state. More importantly, the Constitution itself places the burden squarely on Congress. Inaatas ng saligang batas sa Kongreso ang pagbigay ng malinaw at makatarungang definisyon ng political dynasties. That responsibility cannot be avoided, postponed, or delegated. At the same time, we must harmonize this mandate with other equally important constitutional provisions. Article 5 on suffrage makes clear that no literacy, property, or other substantive requirement shall be imposed on the exercise of suffrage. Article 3 guarantees due process and equal protection of the laws. The Supreme Court in many instances has struck down additional qualifications to run for public office, including drug tests and literary tests, precisely because they infringe on these protections. That is why this committee will proceed with care, humility, and rigor. We will start with the fundamentals. We will seek the wisdom of our legal luminaries. We will ask hard questions. We will listen closely to constitutional scholars, election law experts, and practitioners who understand both the letter and the spirit of our fundamental law. One of the core roles of the House of Representatives on Suffrage and Electoral Reform, House Committee on Suffrage and Electoral Reforms, and of the House of Representatives as an institution is precisely this: to provide a definition of political dynasties that faithfully aligns with the Constitution and harmonizes its various provisions, not one that contradicts them. This hearing is not the end of that process. It is the beginning. Let me also emphasize an important point that is often lost in public discourse. Political dynasties, as noted by the Congressional Policy and Budget Research Department, represent a concentration of power within a family. This concentration is neither inherently good nor inherently bad. The impact of a political dynasty depends on how power is used. But history and evidence also tells us that when dynastic power is abused, it can undermine accountability, weaken competition, encourage corruption, and divert public resources toward private family interests rather than public welfare. This bill is not an indictment of families. It is an affirmation of principles. Equal access, fair competition, accountability, renewal of leadership. The idea that public office is a public trust, not a hereditary entitlement. Today, we begin serious work of translating a constitutional command into a constitutional law. With the support of the President, the Speaker of the House of Representatives, the Majority Leader, and the Filipino people, and guided by the Constitution itself, this committee will do its duty, calmly, carefully, and courageously. Let this hearing be marked not by fear or defensiveness, but by good faith, intellectual honesty, and fidelity to our oath. The Constitution has spoken. The people have spoken. Now Congress must speak through law. Again, we thank our colleagues and our guests for coming here today. In the initial deliberation of this measure, 20 bills have already been forwarded to this committee covering the same subject matter. Maraming salamat po sa inyong lahat. Magandang umaga po at naway magkaroon po tayo ng isang progresibong diskusyon tungkol po sa anti-political dynasty. Thank you very much. Wassalamualaikum warahmatullahi ta'ala wabarakatuh. We have other members who've just arrived. Comsec, please recognize them.
We would like to acknowledge the following members: Deputy Majority Leader Munir Arbison Jr., Congresswoman Attorney Jervil Jinke Beatrix Luistro, and Congressman Lordan Suwan. We would like to acknowledge also the presence of the following from the Office of the President as observers. We have Attorney Audris Bulatao and Ms. Ria Robles.
Thank you, Comsec. Now, before we proceed to the agenda of today, which is basically to discuss about these 20 versions of the anti-political dynasty for few procedural matters, may we request the Comsec for the... Okay. Again, yes, for the consideration, because we have already, in the previous meetings, we have already approved several bills. And copies of these bills have already been delivered to your respective emails. So now we consider approving the substitute bill on House Bill numbers 102, 3101, and 3102. This is regarding the election day? The election day. Okay. So any
Mr.
motion
Chair?
that we like to solicit motion? Yes, Congressman Dalog.
May I move 3101 and 3102. So move, Mr. Chair.
Second, Mr. Chair.
So there's a motion that we approved a substitute bill on House Bills 102, 3101, and 3102. Any objection? It has been seconded. The motion is approved. Next.
Dalawa po yung comrades na yan.
So ano pa?
Yan. Itong
And then?
consideration is
Okay. Again, for the consideration of substitute bill on committee report on the overseas registration and voting, these are House Bills 2293 and 2534. Do I solicit any motion to dispense with the, to consider and approve substitute bill?
Mr. Chair,
Yes, Congressman Dalog.
I move to approve the substitute bill on and the committee report on the overseas registration and voting bills under House Bills numbers 2293 and 2534. So move, Mr. Chair.
So there's a motion that we approve the mentioned House bills. Is there any objection? Any seconds? When seconded, the motion is approved. So we now, ladies and gentlemen, Your Honors, we now proceed to the initial deliberation of measures on anti-political dynasty. Again, to date, there are 19 measures. 20 na? So we have in receipt of 19 versions of the same subject matter, and there's one that was already referred yesterday. So referred to this committee. This is the one that's being authored by Congressman Miro Kimbo. And other two, we are expecting two other measures that will be receiving today, the same subject matter. So all in all, 22. But officially, we are in receipt of 19. 20 na. Okay, 20. So may we also invite we will start with the first bill, I guess, that was referred to, the first bill that was referred to this committee, and request this authors of this bill to, if they wish to make a few, just a brief sponsorship speech. So on House Bill
Tatlong dekada na po ang nakalipas mula nung ratifikasyon ng 1987 Constitution. Malinaw ang nakasaad sa Artikulo 2, Section 26. The state shall guarantee equal access to public service and prohibit political dynasties as may be defined by law. Ngunit, hanggang sa araw na ito, ang mandatong ito ay nananatiling hungkag na pangako. Ang kawalan ng batas na magbibigay ngipin sa probisyong ito ay nagresulta sa garapalang monopolyo ng kapangyarihan ng iilang pamilya sa ating bansa. Ang Kongreso sa mahabang panahon ay naging instrumento upang panatilihin ang status quo na ito sa halip na buwagin. Ang politika sa Pilipinas ay dominado ng mga elitistang angkan na ginagawang negosyo at pribadong pag-aari ang posisyon sa gobyerno. Malinaw na manifestasyon ito ng burokratang kapitalismo at feudalismo. Ang kapangyarihang pampolitika ay ginagamit upang palawakin ang kanilang impluwensya at protektahan ang kanilang mga interes sa ekonomiya at lupa, habang ang mayorya ng mamamayan ay nananatiling lugmok sa kahirapan. Kitang-kita ang lalong paglala nito noong nakaraang halalang Mayo 2025. Ayon sa datos, nagsilabasan ang tinatawag na mga obese political dynasties, mga angkan na may 5 o higit pang miyembro na sabay-sabay na nakaupo sa pwesto. Hindi na lang ito basta fat o thin dynasties. Ito ay sistematikong pag-okupa sa lahat ng antas ng gobyerno mula sa lokal hanggang national. Tingnan na lamang natin ang nangyari dito sa lumantad na malaganap na corruption sa flood control scandal. Bilyong-bilyong piso ang inilaan para sa proteksyon ng mamamayan. Ngunit nananatiling lubog sa baha ang maraming komunidad. Bakit? Dahil sa mga lugar na hawak ng mga dinastiya, nawawala ang checks and balances. Ang pondo para sa infrastruktura ay nagiging gatasan ng magkakamag-anak na politiko at kanilang mga pinapaborang kontraktor. Ang monopolyo sa kapangyarihan ay nagbibigay daan sa walang habas na korupsyon, kung saan ang kaban ng bayan ay nagiging pribadong yaman ng ilang pamilya habang nalulunod sa baha at kahirapan ang mamamayan. Ang ganitong sistema ng patronage ay hadlang sa tunay na demokrasya at kaunlaran. Nililimitahan ito ang oportunidad ng mga kwalipikado, mahusay at may tunay na malasakit na lider mula sa hanay mismo ng mamamayan. Pinananatili nito ang kultura kung saan ang botante ay napipilitang umasa sa limos ng mga patron sa halip na sa serbisyong karapatan nila. Ang House Bill 209 na ating ini-sponsor ang sagot sa matagal ng hinaing ng taong bayan kaugnay sa political dynasties. Sa ilalim ng panukalang ito, ginagawa ang una, definisyon, nagbibigay ng definisyon sa terminong political dynasties na siyang hinihiling ng konstitusyon. Malinaw na tinutukoy dito ang political dynasty bilang konsentrasyon, konsolidasyon o perpetuasyon ng kapangyarihan ng mga magkakamag-anak. Pinagbabawal dito hanggang sa 4th degree of consanguinity or affinity ang sabay o magkasunod na pagtakbo at pag-upo sa pwesto. Kaya Ginoong Speaker, ang pagpasa sa batas na ito ay isang hakbang tungo sa pagbuwag sa monopolyo ng mga ilang makapangyarihan. Oras na para wakasan ang sistemang ginagawang family enterprise ang serbisyo publiko. So, maraming salamat po sa pagkakataong ito, Mr. Speaker.
Thank you, Kong Tino. Yes, Kong Rene, do you also would like to sponsor as one of the authors? Yes, please proceed. You're recognized.
Thank you, Mr. Chair. Mr. Speaker, Mr. Chair, mga kapwa ko mambabatas at sa mamamayang Pilipino. Narito ako ngayon hindi lamang bilang isang miyembro ng kamarang ito, kundi bilang tinig ng isang henerasyong namana ang isang political na sistema na nababaon sa krisis. Kami ang henerasyong isinilang sa pangakong pagkapantay-pantay at greater political participation noong 1986. Ngunit kami lumaki sa anino ng mga monopolya sa politiko ng iilang pamilya at negosyong nasa likod na sumisira dito. Today, we are here to breathe life into our future. We are here to sponsor with the utmost urgency House Bills number 209 and 4784 or the Anti-Political Dynasty Act. Isang panukalang inilibing, ipinagwalang bahala, ipinagliban ng mahigit 2 dekada mula noong ito'y unang isinulong ng Bayan Muna noong 2001. Paulit-ulit itong inihain ng Makabayan Bloc sa bawat kongreso, ngunit binabaliwala lamang. Malinaw sa saligang batas ang pagbabawal sa political dynasties. Subalit sa loob ng 37 years, ito'y nananatiling patay na probisyon, moral clause na walang ngipin, dahil wala itong enabling law. Hindi po ito demokrasya. Nagresulta dito ay isang sistema kung saan ang serbisyong publiko ay tinuturing na pribado at pamanang ari-arian. Isang prangkisa na ipinapasa ng mga pamilya mula magulang tungo anak, mula kapatid, tungo sa asawa, walang katapusang siklo ng pagpapalit-palitan. Ang kabataan, ang pangunahing biktima ng ninakaw ng kinabukasang ito. Sinasabihan kaming mangarap, mag-aral ng mabuti, umambag sa ikaunlad ng bansa. Ngunit kung titingnan natin ang larangan ng pamamahala, ang mga oportunidad ay nakakulong sa may apelido, sa may dugo. Ang sistemang ito ay nagpapalago ng kawalang tiwala at pagkailang ng mga nasa poder. Ipinapahiwatig nito na sa mga susunod pang henerasyon na ang sistema luto na, imposible nang magbago. Tinatakwil at tinututulan namin ang sistemang ito. House Bills 209 and 4784 provide the clear, surgical, and enforceable remedy we need. It defines a political dynasty with precision, the concentration, consolidation, and perpetuation of political power by a family through simultaneous or successive holding of office. It enforces a prohibition with teeth. No two relatives within the 4th degree of consanguinity or affinity can hold or run for office simultaneously, and no one can immediately succeed an incumbent relative. It empowers the Commission on Elections to deny due course to violators and allow ordinary citizens to challenge dynastic candidates. Kaya nga naman, unang araw pa lang ng 20th Congress, inahain na ng Makabayan Bloc ang Anti-Political Dynasty Bill. Because we believe that passing these bills is the first non-negotiable step towards a new and alternative politics. Ito ay pagwasak sa balangkas ng sistemang padrino at pagbubukas ng puwang sa anak ng magsasaka, sa anak ng manggagawa, sa organisador sa komunidad, sa kabataang akademiko, sa milyong-milyong Pilipino na ang tanging puhunan ay pagmamahal sa bayan at ang kanilang kakayahan. To our colleagues who are part of or supported by these dynasties, history is watching. You have a choice to be remembered as defenders of a dying feudal order or as the legislators who responded to the cries of the youth. Huwag na nating patagalin pa ng 2 pang dekada o higit pa ang batas na ito. Huwag na nating lalong isadlak sa kawalang tiwala ang mamamayang Pilipino. Bagkus, isabatas na natin ngayon ang Anti-Political Dynasty Act sa lalong madaling panahon. Let us unlock the gates of public service and unleash the boundless potential of the Filipino people, of the Filipino youth, based on their worth, not their blood. Thank you, Mr. Chair.
Thank you, Congresswoman Tino and Congressman Tino and Congresswoman Rene for your sponsorship. Yes, Congressman Rodriguez.
Mr. Chairman,
Yes.
there are 19 bills,
20.
20 bills, plus there are some co-authors also of the bill. To be able to have this matter be discussed already, especially with the attendance of our resource persons, I move an omnibus motion that all the other bills, their explanatory notes would be their sponsorship speech here in this hearing. Unless, of course, if one would like to, an author would like, without prejudice to an author who wishes to speak, could also be given. But others may agree that to be able to save time so that our people now watching on TV would like to go into what the resource person will say, I move that all the other bills, the 19 bills, be their explanatory notes, be their own sponsorship speeches. So move, Mr. Chairman.
Okay, thank you. So there's a motion. I understand the rationale behind this motion, since we already received 20 and probably we'll be expecting additional 2. So if we allow, I know without prejudice, no, of course we will treat all of the 22 bills on equal footing, no. But if we allow each and individual sponsors to deliver sponsorship, it will take a while. And probably the most important thing that the Philippines is waiting right now is for them to understand what exactly do we mean by anti-political dynasty in the context of electoral process like election. So with due respect to all the members, especially those authors, I can actually enumerate for brevity, enumerate the House bills, including your name, so that the public would also know who are these congressmen who are pushing for this measure. So thank you very much, Congressman Rufus, for pointing that out. Yes, Congressman Irise, before you act on the motion.
I would like to I prepared an explanation of my proposed bill. I've been fighting for this particular bill for 4 decades. It predates the 1987 Constitution, and I would like to be heard.
Action. We can actually recognize you, Congressman Irise. For the other authors, there's an omnibus motion that all explanatory notes of all 20 bills referred to this committee be treated as the sponsorship speeches and remarks of all of these authors, except for, of course, Congressman Irise already
Mr. Chair.
Intimated that he will speak. Yes, Congresswoman Sara Ilago and then Congresswoman Kakabagao, in that order. Yes, ma'am.
Yes, maraming salamat, Mr. Chair. I would also like to reserve my right
Okay.
to deliver my sponsorship speech.
Okay.
Maraming salamat.
Understood. Yes. Congresswoman Kakabagao.
Mr. Chair, I think an explanatory note is very important in this committee hearing. It sets the stage for the discussion, even for issues that should be resolved. So I want to present my explanatory note for
Okay,
today.
but except for the 3, Congresswoman Sara Ilago.
I would actually like to manifest to speak on just a portion of what I wanted to say earlier, as explanatory note.
Mr. Chair.
Yes, yes, Congressman. Thank you. Noted po, Congressman Liamansares. Congressman Jokno.
Similar manifestation, Mr. Chair.
Okay. So, only
Chair
for...
Adyong, in that case, I will also register that I want to explain because that should be fair for everybody.
Okay, yeah. So, Manong Rufus, I understand that we want to save time, but since many of them have already indicated
There are already
their desire-
just 6. And so 6 is better than 20. So that we can proceed with hearing our resource persons. So I suggest with those who have signified to speak, they be given because that is the right to be heard when they have a bill. But others who wish to facilitate the proceedings can therefore just be able to have their explanatory notes be the sponsorship speeches. So 6 will be allowed. We allow them, Mr. Chairman.
So since actually
Mr. Chair.
that motion is not, the effect of that motion is not really to curtail the privilege of the authors, can we just go through na lang? Anyway, if there are members who would not want to read their sponsorship, they can just simply say, submit na lang nila yung sponsorship speech. So would that be okay? So may I humbly request the good congressman from the 2nd District of Cagayan de Oro to withdraw that omnibus motion? We will go
Yes,
through na
I
lang.
always agree with the chairman.
Thank you. Thank you very much. Thank you so much. Thank you.
Mr. Chairman.
now-
Mr. Chairman.
Yes, Congressman Chairman Miro.
If I may just, Mr. Chairman, just with a reminder to everybody that this is not a privilege hour also. So
Yeah.
try to limit the
So
explanation
would
of
that
your...
be okay? Would that be okay if the chair requests that all authors limit their sponsorship remarks to maybe 2 minutes? Would that be okay? Would that be okay? What is important is our guest. We would like to hear and solicit inputs from our guest, no? Kasi alam naman po natin ang posisyon ng bawat isa sa atin. The mere fact na nag-author ka, 60 seconds, no? 60 seconds? Okay, 2 minutes. Would that be okay? 2 minutes. Thank you. So before we proceed to the next House bill, may I first acknowledge Congressman Brian Po Llamansares of the FPJ Panday Bayanihan Party List. Thank you, sir, for joining us. Congressman Richard Gomez from the 4th District of Leyte. Dapat dito ka nakatabi kasi yung camera dyan pupunta sa iyo eh. One of our deputy majority leaders from One Rider Party List, my good friend, Congressman Ramon Rodrigo Gutierrez. From the 3rd District of Pampanga, AML Congresswoman Alisa Micaela Gonzalez, and also from the convener from Contra Daya, Ms. Rochelle Porras. Thank you. So, Sir Egay, we go through na lang po yung sequence nung pag-receive po natin ng bill. So, now we proceed to House Bill number 381, authored by Representative John Keith Flores. I believe Congressman Flores is attending IPA, so he's not around to sponsor his...
Mr. Chairman,
Congressman, yeah,
I would move that the sponsorship of the explanatory note of my neighbor from Bukidnon be considered as his sponsorship speech. Thank
There's
you.
a motion that this explanatory note of the bill be made as the sponsorship remarks of the author. Is there any objection to it? Hearing none, so the motion is approved. So we proceed with House Bill 874, authored by Representative Margaret Q.T. Delmar.
Mr. Chair.
Did we notify? Yes, Congressman.
Yes, I've been asked by my batchmate, Congresswoman Q.T. Delmar, in deference to the previous motion, that her explanatory note be simply adopted as her sponsorship speech.
Okay, so there's a motion that the explanatory note of House Bill 874 be treated as the sponsorship remarks by Congresswoman Delmar. Thank you, Congressman Gimbo. Now we proceed to House Bill 909, authored by Representative Bernadette Barbers. Did we notify her that we will be having our committee hearing here? So anyone who would like to, yes,
Mr. Chairman, on behalf of my fellow Mindanaonon from Surigao, we're not calling ourselves Mindanaoans because an American derogatory word said, you know, Mindanaoans like Californians, like Georgians, are troublesome and warlike. That is because we fought against the Americans and the Spaniards. I move that a fellow Mindanaonos bill be considered her explanatory note be considered as her sponsorship speech. Thank you, Mr. Chairman.
Thank you, Congressman Rufus. So the explanatory note of House Bill 909 be treated as the sponsorship remarks. Thank you. Approved. House Bill 1297, authored by Representative Mark Anthony Santos. Sir?
Yes, Mr. Chair, thank you very much. I move that my explanatory note be my sponsorship speech. Thank you, Mr. Chair.
Thank you very much, Congressman Santos. So House Bill, we proceed to House Bill 2037, Representative, of course, Edgar Irice.
Thank you, Mr. Chair. Bago po ako magsalita, humingi na ako ng paumanhin. Trabaho lang, walang personalan. This is now my 5th term in Congress, and I have consistently fought for the enactment of the anti-political dynasty law, not only as a sworn duty to uphold Article 2, Section 26 of the 1987 Constitution, but as part of my lifelong battle against political dynasties. My advocacy against political dynasties predates the 1987 Constitution. For more than 4 decades, I have fought entrenched dynasties in my city. Personal ko pong naranasan bilang isang ordinaryong kabataan noon, walang sikat na apelyido, walang kamag-anak na politiko kung paano hamakin, alipustahin at takutin ang isang taong gustong maglingkod sa bayan. Alam ko kung papaano sumuot sa butas ng karayom upang makapasok sa paglilingkod sa bayan. I was bullied. I was chased by goons. My family was threatened. Our headquarters were ransacked. My supporters were hurt and intimidated. Barangay and SK officials who supported me, my candidacy, were suspended, harassed, and punished. These are not theories to me. Ito ay buhay na karanasan. That is why I know both in my heart and in my mind the mindset of entrenched political dynasties. Their mindset revolves around entitlement. They see themselves as natural leaders, as if governance is a family inheritance and a divine right. They convince themselves that the people cannot thrive without their continued presence. In their minds, political positions become family heirlooms rather than a public trust. And this mindset weakens democracy. Lumakas at tumaba ang mga political dynasties noong panahon ng rehimeng Marcos. The dictatorship found it convenient to sustain regional and provincial dynasties to remain in power and suppress dissent. The principle was simple. You scratch my back, and I'll scratch yours. And we both remain in power. In doing so, public funds became dangerous tools to perpetuate dynasties. Principles of public finance were ignored. All that mattered was to stay in power. The result, from being the second biggest economy in Asia in the 1960s, napag-iwanan na tayo ng mga bansang dati malayong-malayo ang ekonomiya sa atin. Ang pinakamahihirap na communities sa ating bansa ay pinangungunahan ng mga political dynasties. The wisdom of the framers of the 1987 Constitution was precisely to dismantle these dynasties because they block progress, monopolize power, and deny equal access to ordinary Filipinos who have the talent, the skills, and the integrity to lead. My colleagues, let us not forget the violence born out of greed for power. The assassination of Senator Ninoy Aquino in 1983, the killing of Evelio Javier of Antique, the Maguindanao massacre in 2009, and many others whose names history may not fully remember, but whose blood stains our democracy. My version of the anti-political dynasty bill is the product of persistent and principled advocacy. In fact, this was the first proposal that passed Congress, the Committee on Suffrage and Electoral Reforms in 2015. It reached the plenary, was debated, was eventually archived because the forces of political dynasties refused to surrender even a single vestige of their power. This proposal is a reasonable and enforceable compromise. It allows Okay, I will continue. It allows only 2 members of a family to hold public office simultaneously, one at the national level and one at the local level. If passed, Fat dynasty will definitely disappear. It limits the prohibition to the second degree of consanguinity, meaning it applies only to the immediate family household, mag-ama, maglolo, magkakapatid at kanilang mga asawa. Beyond the household, enforceability becomes unrealistic and arbitrary. Hindi makatwiran at hindi na epektibo kung pati magpipinsan at mas malayong kamag-anak ay babawalan. My bill is easy to enforce. Kung ang iyong immediate family ay hindi magkasundo at sabay-sabay kayong kakandidato, pareho kayong madidisqualify. Simple lang ang katwiran. Kung ang sarili mong pamilya ay hindi mo kayang pagkaisahin, paano mo pamumunuan at pagkakaisahin ang bayan? In this manner, pinapalakas natin ang pamilya, ang basic unit ng lipunan, habang iniiwasan ng mga trahedyang dulot ng politika, magkakapatid na nagbabangayan, maglolo na nag-aaway, mag-ama na nagbabastusan, at minsan nagpapatayan pa dahil sa kapangyarihan. This proposal is not an attack on families. It is a defense of democracy. There are good dynasties who brought progress in their localities, but they are exceptions rather than the rule. If they are truly good, then one or two of them can lead the government. For the rest of them, they can choose to serve through community work or businesses that can help our country. This bill fulfills our constitutional duty as we see the consequence of decades of our inaction. Ghost projects, politicized social aid, and the mismanagement of public finance. Tama na, sobra na, ngayon na, ipasa na natin ang batas na ito. Salamat po.
Thank you very much, Congressman Irise. Now we proceed to House Bill. Okay, before we do that, I'd like to acknowledge Congressman Antonino Roman III of the 1st District of Bataan. Thank you very much, sir, for joining us today. And one of the authors of the House Bills, House Bills on Political Dynasty from the 2nd District of Surigao del Norte, Honorable Bernadette Barbers. Thank you, ma'am po, sa pagdalo. Now we proceed to the next House Bill, which is House Bill 2131, authored by Representative Laila De Lima of the ML Party List.
Mr. Chair, dear colleagues, thank you. I'm actually adopting as my sponsorship speech the explanatory note of my bill, House Bill number 2131, but I have a short manifestation only, Mr. Chair, if I may. My bill is about second degree, is up to second degree of relationship, consanguinity or affinity. But I'm actually open to extending it up to fourth degree. I'm open. So my position or my bill with respect to limiting it to second degree only is rather tentative because I've made further review, further study, and I realize that there are other laws that actually speak of fourth degree, like the Administrative Code of 1987 with respect to the limitations, restrictions on appointments under Civil Service Commission, Commission on Elections, and also the Local Government Code. If we would limit the anti-dynasty prohibition to second-degree relatives only, said prohibition can be easily circumvented or defeated by merely passing the public office to their third-degree relatives or fourth-degree relatives. And it will also raise false hopes. Kasi bibigyan ng chance, ang magiging argument dito, bigyan natin ng chance na up to second degree, only to realize later, after years, that it actually doesn't work. So I'm open to extending to up to fourth degree, but as I mentioned here, because I'm open also to listening to other views on the matter, and I would, at the end of our deliberations, then I would be able to make a decision as to whether it's second degree or fourth degree. Thank you very much.
Thank you, Kong Laila, for your sponsorship. Now, we proceed to House Bill 4784, authored by Representative Sara Jane Ilago of the Gabriela Party List.
Magandang araw sa lahat. Isa ang pulong na ito sa pinakainaabangan ng ating mga kababayan na galit na sa konsentrasyon ng kapangyarihan na isa sa mga nagbibigay daan sa malawakan at malakihan na korupsyon at pagnanakaw sa kaban ng bayan. Political dynasties have become so obese with power that they have monopolized not just positions, but the very hope for genuine representation and leadership at all levels. This must end. And House Bill number 4784, which prohibits political dynasties within the fourth degree of consanguinity or affinity, is both urgent and necessary to address this. Now, some will rise and claim that this prohibition may undermine democracy, that the problem is the rotten system that breeds it. Tama naman po iyon. No? Indeed, political dynasties are not the root cause of the problem, but they are the most visible fruit of the rotten tree of traditional politics. A system sustained by corruption, by patronage politics, by the infamous guns, goons, gold, and now with technology, even glitches. Dynasties flourish precisely because the system has allowed two things. First, the flood of political money that drowns out ordinary candidates. And second, the glaring, deliberate absence of a law to stop them. This bill hopes to correct that second failure. It attacks the system by dismantling its most entrenched structures. And as a representative of Gabriela Women's Party, I see another layer of this dynastic situation. In our communities, we ask, what is a woman's place in political dynasties? The 2025 Global Gender Gap Index reports that the Philippines has a low parity score of 37.7% out of 100% in the political empowerment of women. Napakababa po nito at isa sa mga itinuturo na sanhi ay ang maraming political dynasties na minsan o madalas itinatrato lamang bilang mga placeholders ang mga kababaihan. Hindi dapat ganyan ang sitwasyon. This bill, by breaking dynastic control, liberates political power from being just a family interest and creates space for genuine women leaders and all leaders, especially from those from marginalized backgrounds, to rise on their own merit. So what is the path forward? First, we must pass this specific, stringent prohibition that no two relatives within the fourth degree should hold or run for elective office simultaneously. We believe that this is the clearest line we can draw against the monopolization of power. Second, we must stop here. We must not stop here. No, hindi po tayo dapat tumigil lang dito. We must continue the fight for economic and political reforms, campaign finance reform, genuine agrarian reform, even the fight for living wages. Lahat po ito naghahangad na mas maiangat ang kabuhayan, ang kalagayan ng ating mga kababayan para may makita naman tayo na nagmula sa hanay ng mga magsasaka, mga mangingisda, mga ordinaryong tao, mga teacher, mga manggagawa na makakatakbo at magkakaroon ng mas malaking tsansa na makapanalo ng mga posisyon sa ating pamahalaan. And third, we must be clear-eyed. The struggle to change a system that genuinely serves the ordinary people's interest does not end with this bill's passage. The fight for genuine representation continues. History is watching. The marginalized sectors are watching. The Filipino women are watching. Wala pong kukurap sa pagbabantay sa pagpasa ng isang tunay na anti-political dynasty bill. Maraming salamat.
Maraming salamat po, Congresswoman Ilago. Now we proceed to House Bill number 5334, introduced, authored by our Deputy Majority Leader, Ramon Gutierrez.
Thank you, Mr. Chair.
Gutierrez of the One Rider Party List.
Mr. Chair, in the interest of time, I'll also be having my sponsorship speech. In place of a sponsorship speech, I will just have my explanatory note. But a short manifestation, Mr. Chair, I filed this bill out of fidelity to the Constitution. I understand, however, that this would take a lot of compromise, especially conditions of our, the political climate, and considering this is a very political bill. I just want to mention also, as Congressman Lim has mentioned, my openness to compromise. I filed this bill. It's pretty lean, considering that I've been targeting only successive dynasties rather than simultaneous incumbencies. But understanding the limitations, I'm also open to whatever the discussions would be in this committee. Thank you very much, Mr. Chair.
Thank you, Kong Raj. Now we proceed to House Bill 5871 from the Lone District, the gentleman from the Lone District of Pasig City, Representative Romanti Romulo.
Thank you, Mr. Chair. Just a short manifestation. I don't want to belittle the experience of some members here who, like Honorable Erice, who mentioned what he went through because of dynasties. But of course, we cannot also set aside victories that happen. Right here, we have with us the representative from Las Piñas, Honorable Mark Anthony Santos, who was able, despite all the odds, is here with us now. The point, Mr. Chairman, is that this is not an easy issue. In fact, if you read the deliberations in the CONCOM, definitely pinag-usapan nila dalawa, sa local government and sa national government. And sa parehong instance, nahirapan nga sila to come up with a final statement on dynasties. Kaya, in fact, pinasa nga nila sa Kongreso. That is why there are issues that we must listen, we must hear from our resource persons. Example, ano ba ang gusto ng Kongreso? Is it succession lang? Ang pagbabawalan ba natin? or simultaneous holding. Because if you read the deliberations, what they intended was merely succession, not simultaneous positions. So do we want to expand that? I think we should hear from one another and the experts. Again, another issue brought up during the CONCOM was also mentioned earlier. Paano naman yung right to suffrage? Included there is the right of every Filipino to vote and be voted upon. So if we are going to defeat or if we are going to make an exception, I think dapat klaro tayo bakit tayo may exception. Kailangan maliwanag na lahat tayo, ito yung rason natin kung bakit natin gustong ipasa ito. Again, this is not an easy issue. But again, we want to deliberate on this and we want to pass a version that is fair to all and will not trample upon any constitutional right. Thank you, Mr. Chairman.
Thank you, Congressman Robolo, for that thought-provoking remarks. Now we proceed to House Bill 5905, introduced by Representatives Bagao, Sindanya, and Jokno and Esmula from the Akbayan Party List. Yes, ma'am, sino pong mauna? Yes, Congresswoman Bagao.
Thank you, Mr. Chair. Isa po talaga ito sa dahilan kung bakit ako tumakbo sa eleksyon at nandito sa bulwagang ito. Ka-excited po ako. Studies consistently show that areas dominated by political dynasties experience higher poverty, deeper inequality, and weaker public accountability. This is not accidental. Political dynasties thrive on patronage, and patronage weakens checks and balances and amplifies corruption. At damang-dama po namin ito sa Dinagat Islands na sa isang yugto ng aming kasaysayan ay higit 17 posisyon na elective ay pag-aari ng iisang pamilya lamang. Kaya ano po ang kwentuhan sa ganitong lugar? Sabi, kapag nag-end ang term ni tatay, ay papalitan ng nanay. Sasabihin ng nanay, ayoko naman talaga. Pero wag kayong mag-alala, 3 taon lang to, babalik naman siya ulit. Sa amin, palaging maririnig, ang posisyon ng mayor o gobernador ay minanapan namin sa aming ninuno. Dapat sa amin lang ito. O kapag naubusan na ng kandidato at ipinalit si Bunso, bilang mayor ay hindi mo makikita sa munisipyo. Dahil maghapon at magdamag na naglalaro ng computer games, ay kapag ginising mo, ang sasabihin sa'yo, kausapin yung tatay ko, siya talaga ang totoong mayor. Pansamantala lang ako. Sa kabilang dako sa mga magsasaka, ang sasabihin nila kahit mahusay silang leader, wala tayong tsansa dyan. Dahil nasa pamilyang yan ang lahat ng pera, kapangyarihan, at impluensya. Anong laban? That's why we should not forget Article 2, Section 27 of the Constitution. And let me emphasize, just 2 phrases. Equal access to opportunities for public service. At yan ang matagal na reklamo ng mga mahihirap at ordinaryong mamamayan. At specifically, sabi ng Konstitusyon, prohibit political dynasties. This is not a qualification. This is a compliance to a constitutional requirement. That's why, hindi po natin pinagbabawalan ang lahat ng magkakamag-anak na tumakbo. Huwag po natin yan i-confuse mga kasama, mga kababayang nakikinig. Hindi po lahat. Kasi ang dami pong sa isang probinsya, pwede pong lahat kayo ay magkakamag-anak. Kapag pinagbawalan po natin lahat, wala na pong pwedeng tumakbo. Medyo weird po yun. Hindi naman po. That's why Akbayan's House Bill 5905 only seeks to establish an anti-political dynasty relationship where, number 1, the spouse or relatives up to the 4th degree of consanguinity or affinity of an incumbent elected official, including a party list representative, runs for or holds any elective public office. 2 or more relatives up to the 4th degree of consanguinity or affinity run simultaneously for elective office, including through the party list nominations or substitution. Or 3, a spouse or relative up to the 4th degree of an incumbent elective official, including a party list representative, succeeds to the office of the same or any incumbent elective official. Simply put, no family members should be allowed to take turns or run for office at the same time just to keep political power within their household, whether in the local government, national office, or even in the party list system. And this bill, House Bill 5905 of Akbayan, will surely open the doors for leaders who have the competence to lead, like a teacher, leader ng magkasaka, ng mangingisda, ng mga katutubo, ng kababaihan, kabataan, ordinaryong mamamayan na matagal nang may kakayahan na mamuno at mamahala, pero walang access para mag-participate sa ganitong larangan ng eleksyon. It restores the principle that leadership and power should be anchored on service, not inherited through bloodline. Kaya Mr. Chair, salamat sa pagkakataon. Sana po, wag nating hayaan na ang kinabukasan ng ating sambayanan ay pinag-uusapan ng isang pamilya lamang habang kumakain ng almusal, tanghalian at hapunan. Maraming salamat, Mr. Chair.
Thank you, Representative Bagao, for your sponsorship. Yes, is Congressman Jokno?
Yes, Mr. Chair, may I be allowed to make some remarks also on behalf of Akbayan Party List? Well, Mr. Chair, esteemed committee members, good morning. On behalf of Akbayan Party List, I am truly honored to sponsor House Bill number 5905, or the Comprehensive Anti-Political Dynasty Law. 38 years have passed since the Constitution commanded that Congress pass an anti-political dynasty law. And yet, we are here today only beginning the process. The intent of the framers was crystal clear. Democracy must not be undermined by the concentration of power in a few families. Public office must remain a public trust, hindi po pamana ang posisyon sa gobyerno. House Bill number 5905 seeks to finally give teeth to that constitutional provision by providing a clear definition of political dynasties and delineating prohibited relationships and scenarios. We are not without precedent, Mr. Chair. The Sangguniang Kabataan Reform Law prohibits relatives of elected officials up to the 2nd degree of consanguinity or affinity from running as SK officials. This is so far the only national law with a clear anti-dynasty provision. But at the regional level, the Bangsamoro government has taken bolder steps. The Bangsamoro Electoral Code lists political dynasties as a ground for disqualification. And under Section 45G of the Bangsamoro Local Governance Code, electoral candidates for barangay, municipal, city, and provincial positions must not have relatives within the 2nd degree of consanguinity or affinity who are incumbent officials in the same locality running for elective positions. But while these efforts are commendable, they are piecemeal. Ang kailangan po natin ngayon ay isang pangmalawakang national law that applies across the board and fulfills the democratic promise of equal access to public service. The urgency could not be clearer, and the evidence is very strong. A study by the Ateneo Policy Center reveals that political dynasties controlled 29% of elected positions in 2019. Ang ibig po sabihin nun, 1,548 political families held office with 339 clans having at least 3 members in power in 2019. But Mr. Chair, this phenomenon is not limited to local politics. The Philippine Center for Investigative Journalism has reported that in the 19th Congress, 66% of party list groups included at least one nominee from an established political dynasty. But there is an even more troubling reality. Political dynasties exacerbate poverty in resource-rich provinces outside Luzon. In those areas, the concentration of both political and economic power fosters extractive governance. So-called fat dynasties use their influence to extract rents, maintain patronage networks, and shield themselves from accountability, leaving citizens with reduced access to public services, weaker institutions, and deeper economic stagnation. Political dynasties crowd out new voices, suppress local competition, and often place loyalty to clan above loyalty to the Constitution. The time has come to put country over political or familiar interests and pass the comprehensive anti-political dynasty law. Nasa atin po ang constitutional mandate, nasa atin ang legal framework at precedent. We have more than enough empirical evidence to show how this will benefit our nation. Ang kailangan po natin ngayon is the political will to act. Hindi bukas, hindi sa susunod na Kongreso, kundi ngayon mismo. Maraming salamat po.
Maraming salamat po, Congressman Diokno.
Mr. Chair.
Yes, any other? Yes, Congressman Sindanya.
Maraming salamat. Thank you very much, Mr. Chair. And good morning to our colleagues and our resource persons. Maikli lamang po manifestation. Ang ating pong gay lingo of the week ay DEDMA. DEDMA, which means to disregard, consciously disregard or ignore. Batay po sa bilang po dito, it has been 14,240 days na dinededma po ng Kongreso ang mandato ng Konstitusyon to create an enabling law that will give legs, hands, and teeth to this provision of the Constitution. At ito po ng dededma natin, itong pang-dededmang ito has resulted into catastrophic impacts on our political system and the lives of ordinary Filipinos. I reiterate the calls of Akbayan Representative Chel Jokno and Dinagat Islands Representative Kakabag-Aw. That is the need for the immediate passage of a comprehensive, again comprehensive, anti-political dynasty legislation. Marami po nagsasabi, grabe naman, fourth degree. Magre-result yan sa mass extinction. But if that mass extinction will result into the mass extinction of corruption, patronage politics, and poverty, then so be it. The past year has been marked with revelations of unprecedented corruption. And this leads us to a sobering conclusion that the common denominator to corruption are political dynasties. Hindi katakataka ang galit ng mamamayan sa ating mga institusyon, lalong-lalo na sa Kongreso. Pero may oportunidad tayo mga miyembro ng 20th Congress na mapanumbalik ang kahit katiting na tiwala ng taong bayan. Panawagan natin sa ating mga kapwa mambabatas, tama na ang ating pangdededma. Gawin natin ang 20th Congress na kongresong nagwasto sa ating mga sarili na hindi tayo bingi sa hinaing ng mamamayan at hindi tayo ng dededma. Maraming salamat, Mr. Chair.
Mr. Chair.
Thank you, Congressman Sindanya. Yes, Congresswoman Kiram.
Yes, thank you, Mr. Chair. Just a short manifestation. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuhu. Naniniwala po kami sa akbayan na ang anti-political dynasty bill ay hindi lang usapin ng kung sino ang pwedeng tumakbo. Usapin ito ng buhay at kapayapaan. Hanggat ang kapangyarihan ay monopolyo ng iilang pamilya, maghahari din ang armas at dahas sa iilang probinsya. Anti-political dynasty bill is a peace and development measure. If we end domination of political dynasty, we end warlordism. We end violence. Maraming salamat po, Mr. Chair.
Maraming salamat po, Akbayan representatives. So before we proceed to the next House bill, may we first recognize, acknowledge from the Lone District of Maguindanao del Sur, Assistant Majority Leader, Congressman Ismail Toto Mangudadato. Thank you, sir, for coming. and to sponsor House Bill number 6064. May we hear from the author, Representative Dumogan, in the Lone District of Baguio City. Manong? Kong Dumogan.
Thank you, Mr. Chairman. 20 of us authors, we are against political dynasty. Everything had been said about the negative effect of political dynasty. And I do not like to repeat on those already been stated. I give important on those already been stated. I give important to these resource speakers because reading all the bills, there are few differences. One, as to the degree of relationship. Two, as to whether or not this degree of relationship should not be allowed to succeed. I said, we can listen to our resource speakers on how we can be helped to come out with a common definitions on these conflicting versions of the different bills filed. Thank you, Mr. Speaker.
Thank you po. Thank you po, Manong Congressman Dumogan. And to sponsor the bill of the Speaker, Speaker Boji D, and the Majority Leader, Ferdinand Marcos, may we recognize Congressman Talog for House Bill 6771.
Mr. Chair, I move that the explanatory note of House Bill 6771 be the sponsorship speech of Speaker Boji D and Majority Leader Ferdinand Alexander A. Marcos. So move, Mr. Chair.
Thank you. So there's a motion that the explanatory note of House Bill 6771 be treated as a sponsorship remarks of the authors. Is there any objection? Hearing none, the motion is approved. Kong Luisto, you have...
Mr. Chair,
Yes.
I wish to express my strongest support to the manifestation of Chair Romulo. And in this light, Mr. Chair, I manifest the interest to hear the insights of then members of the Constitutional Commission. I understand we still see them around, no? We have Attorney Christian Monsod, former Justice Secretary Ascuna, Attorney Sarmiento, and even retired Justice Secretary Supreme Court Justice Carpio, no? I totally agree with Chair Romulo that the bill should be very much aligned to the intention of the 1987 Constitution. For us to be able to determine that, we really need to know the intention of the framers of the 1987 Constitution when they included in our Philippine Constitution the prohibition against political dynasties. That is a manifestation, Mr. Chair.
Thank you. And for the information of the good Congresswoman from Batangas, we have actually sent an invitation to all those mentioned personalities. We believe, the committee believes that it is imperative that we listen the inputs and the explanation, especially from those who were responsible for coming up with the 1987 Philippine Constitution. We have already sent them invitation and we're just waiting for the responses. But one actually, a former retired Chief Justice, also sent his representative. So we're just waiting for them to arrive and maybe probably in the coming next hearings. We hope that we can have them so that we can hear their explanation, how they can guide us in crafting the anti-political dynasty bill. Thank you very much for that manifestation, Congresswoman Luistro. Now to move to sponsor House Bill 6799, may we hear from the author of the measure, Representative Lordan Suan of the District of Cagayan de Oro City.
Mr. Chair, I move that my explanatory note be considered as my sponsorship speech.
Thank you, Representative Suan, for that. Thank you very much. So now House Bill 6826, Representative Raymond Adrian Salceda. Comsec, did we notify Congressman Salceda? Anybody from the... Yes,
I
Congressman
move that
Dalog.
the explanatory note be considered as his sponsorship speech.
There's a motion that the explanatory note of House Bill 6826 be treated as the sponsorship remarks of the author. Any objection? Hearing none. Any second? It's been seconded. The motion is approved. House Bill 6886, authored by Representative Brian Paul Manzares. Sir, you recognize.
Mr. Chair, thank you for the time. I would like to first acknowledge all my colleagues here, many of which come from lasting political legacies. It is my hope that the Filipino people see the sincere effort of the House of Representatives to pass lasting legislation that will encourage a more fair democracy within our country. With over 20 versions filed, even the Speaker himself filing a version, I think that the Filipino people should note na iba-iba yung mga versions po natin, pero isa lang ang gusto natin, maging mas patas ang demokrasya sa ating bansa. And so with that being said, House Bill number 6886 is not a measure of exclusion or punishment. This bill adopts a measured and reasonable approach to operationalizing the constitutional prohibition. To ensure fairness and avoid uncertainty, the bill establishes an objective resolution mechanism through an official order of precedence for the Board of Canvassers. This includes, first, a voluntary agreement. The first and most respectful step would be to have a voluntary agreement. Second, if no voluntary agreement is reached, the law then applies a precedence of higher office. So national office takes precedence over local offices, provincial offices take precedence over city or municipal offices. And if so, COMELEC determines the specific hierarchy based on official order and succession. Third is a precedence of larger constituency. Should related candidates be elected to offices of equal rank, the bill looks at precedence of larger constituency. The candidate who represents the greater number of people, determined by either total population or the number of registered voters in their territory, shall be the one proclaimed. And finally, as last resort, when all other objective rules are inapplicable or fail to be resolved, the board will proceed with the drawing of lots. These mechanisms are designed to be objective, transparent, and free from political bias. They ensure that the Board of Canvassers issue a clear certificate of proclamation that explicitly states the specific legal bias for their decision. Honorable Chair, the reason why I'm specifically mentioning this in my explanation for this bill is because we want to do away with the unnecessary contradictions in possibly running for office, in which maybe political opponents may use or leverage this bill to stifle democracy by taking away someone's right, by utilizing this the wrong way. We want to encourage the spirit of democracy in its truest sense. So with that being said, I hope that these provisions will be taken into consideration, but I also hope that the Filipino people see that we are doing our duty here today. Maraming salamat po.
Maraming salamat, Congressman Brian, for your sponsorship speech. Now we proceed to House Bill 6888, authored by Representative Itzel Galios.
Mr. Chair?
Yes, Congressman
I
Dalog.
move likewise that the explanatory note of House Bill number 6888 be considered as the sponsorship speech.
Thank you. So there's a motion that the explanatory note of House Bill 6888 be treated as the sponsorship remarks of the author. Any objection? Any second? It's been seconded. The motion is approved. House Bill 6894, introduced by the former President, Representative Pampanga Representative Gloria Macapagal Arroyo, and Congressman Arthur C. Yap. May we hear, maybe Congressman Dalog, would you like to sponsor the measure? Yes, isa lang.
The same manifestation, Mr. Chair, that the explanatory note be made as the sponsorship speech and of House Bill number 6894.
Thank
So
you. Thank you, Congressman Dalog. So the explanatory note of House Bill 6894, introduced by the former President and Congressman Yap, be treated as the sponsorship remarks of these authors. Any objection to that motion? Been seconded. So the motion is approved. House Bill 6925, introduced by Representative Christopher Son Coco M. Yap. Again, Congressman Dan, would you like to do the
Yes,
pleasure of...
Mr. Chair, I move that the explanatory note be considered as the sponsorship speech of House Bill number 6925. So move.
Any objection to that motion? Any objection to the motion? Hearing none, the explanatory note is treated now as the sponsorship speech of Congressman Yap. House Bill, pinakaihintay, House Bill 7072, introduced by Representative Attorney Miro S. Kimbo. Sir, we are eager to listen sa speech mo po, sir. You're recognized.
I move that we adopt. Mr. Chairman, marami nang naipaliwanag. Tingin ko, malinaw naman yung manifestation sa kapaliwanag about the evils that political dynasties bring. Ang gusto ko na lang sabihin is, nais natin iparating na seryoso kami sa usaping ito. Pinagdaanan ko na sa ibang kongreso, pang-5 termino ko na ito. Naramdaman na ho namin yung usapin na dati na hindi ito naitutuloy sa isang dahilan. Kapag hindi, magtutuloy-tuloy tayo dito. Panghuli ko na lang po na pakiusap, ramdam na ramdam namin sa pamumuno ni Speaker Boji D na seryosong-seryoso siya at sisiguraduhin niyang maipasa ito. Sana lang, ang political dynasties by itself is not an evil thing. Nandyan na yan sa rurok nung pinag-uusapang tagumpay ng ating ekonomiya in the 60s. Nandiyan na ang mga political dynasties. Nagpapatayan pa nga mga tao noon. Pero kung may iisang bagay na tingin kong kailangan din nating tingnan is that we cannot address the political failures of our system simply by having an anti-political dynasty bill or law. Because sala-salabat dito, ang pangunahing cost of political dynasty, makikipagdebate ako kahit kanino, ay ang term limits. Simula't simula nilagay ang term limits, nag-multiply at dumami ang political dynasties. Kung pinapayagan, pinapahintulutan, magtuloy-tuloy, tulad ng ibang demokrasya, ang pagpapatuloy ng paglilingkod, ang likelihood ng pagkakaroon ng political dynasty na di-diminish by at least 60%. So importante, ang nakakahiya, o wag naman po, ang mas hindi katanggap-tanggap ay nagkakaroon tayo ng mag-asawa, magkasunod ng posisyon. Pasensya na po kung may masasaktan. Tingin ko po ito yung ayaw ng taong bayan pag nawawala ang checks and balance, ito ang nagiging pangyayari. So, yun na lang po ang aking pakiusap. Mr. Chairman, congratulations on your handling of this very, very difficult issue.
Marami pong salamat, Congressman Kimbo, sa iyong talumpati. Maraming salamat po. So, I think mayroon pang nadagdag po ngayon lang. Kagabi, si House Bill 1796 ni Representative Iris Marie Montes. Ito po siya. So we are in receipt of the letter from the author. So, if Congressman Dalogs, in the interest of time.
Yeah. I move that the explanatory note of House Bill number
7
7076 be 7096 be considered as its sponsorship speech. So move.
So there's a motion that the explanatory note of House Bill 7096 be treated as the sponsorship remarks of the author. Any objection to the motion? Wala naman. So it's been seconded. Motion is approved. Thank you all very much to the authors for all your sponsorships. Yes, Congressman.
Madam
Rodriguez.
Chair, the author of House Bill number 909, the Honorable Bernadette Barbers, my fellow Mindanaonon, is already here.
Yeah.
Although earlier I moved for her explanatory note to become her speech, can we hear the Honorable Representative of Surigao?
Yes, Congresswoman Barbers, yeah, would you like to address this body as one of the authors? We have already adopted the explanatory note as your sponsorships, and of course, but if you'd like to say something. Yes, please. You're recognized po, ma'am.
Good morning, Mr. Chair. Our esteemed colleagues, distinguished guests, and ladies and gentlemen. Allow me to deliver my sponsorship speech for House Bill 909, entitled An Act Defining Political Dynasty and Prohibiting the Establishment thereof. For decades, our democracy has endured a hard truth we have been unwilling to confront. In many places, elections no longer offer real choices. Political power simply rotates within the same surnames. That is not democracy. It is a political entrenchment. The Constitution is explicit. Political dynasties must be prohibited. Yet this mandate has long been ignored, allowing public office to be treated as a family asset rather than a public trust. This bill finally gives effect to the constitutional command. House Bill number 909 is clearly restrained and enforceable. It defines political dynasties within the second degree of consanguinity or affinity and prohibits simultaneous office holding and immediate succession by close relatives in the same locality. It bars monopolies of power, not participation in public service. The measure applies prospectively, respects existing term limits, and ensures meaningful enforcement through sworn declarations, swift COMELEC proceedings, and the classification of violations as an electoral offense. Mr. Chair, delaying these reforms means accepting inherited power over earned leadership. The Filipino people deserve genuine choice in our elections, and I respectfully urge the committee to give this measure its favorable consideration. Thank you, Mr. Chair.
Thank you very much po, Ma'am Congresswoman Barbers, for your remarks. Again, gusto ko lang po magpasalamat sa lahat ng bawat isang author po ng tong measure na to. Indeed, all your inputs and your explanation on your proposed measure would definitely guide the discussion of this committee as we pursue, providing the legal and at least sana, yung acceptable definition on what political dynasty is. Now that we have heard your sponsorship remarks, we would not like to hear the comments and the inputs from our guests. But before I recognize first, I think COMELEC, I think COMELEC, Chairman Garcia they will be having their in-bank meeting today. So with the permission of the members, I would first request COMELEC to respond and maybe to share to us their opinions and inputs on this measure. But before I recognize Chairman George Garcia, let me just premise the discussion on four basic questions. I think these questions have already been explained through the explanation of sponsorship remarks of our individual authors. But let me just
lay down and ask these legal questions that many of us would like to know, especially the non-lawyers here. Number one question, on definition of scope, because we're talking about political dynasty, again, this has already, time and time again, has already been asked by many of us here. How do we even define, approach, and provide legal definition, working definition on the dynasty in the context of a democratic country such as ours? So the question is, how should we define a political dynasty with sufficient precision to avoid ambiguity and inconsistent application with Article 2, Section 26 of the 1987 Constitution? What degree of consanguinity or affinity should reasonably fall within the prohibition and on what constitutional basis can such limits be justified? On constitutional rights and democratic principles, question, how do we balance the tension or harmonize the prohibition of political dynasties without infringing upon the constitutional right to suffrage or the guarantee of equal protection under the law? Do restrictions on political dynasties reconcile with the fundamental right of individuals to seek public office? I think this has also been aired and manifested by Congressman Romulo. Is the prohibition consistent with democratic ideals of meritocracy and equal access to public service? And lastly, in the hierarchy of fundamental rights, what right should prevail? So these are basic legal questions that we'd like to be at least be answered, probably addressed by our legal luminaries present here today. So again, to give way for the COMELEC to proceed, I think today they will be having their en-banc meeting to discuss about the BARM election, because which it is also equally important. No, may we hear first from the Commission on Election Chairman George Garcia, sir.
Maraming salamat po, Mr. Chair, the honorable members of this committee, the honorable members of the House of Representatives, sa ating pong mga panauhin, sa inyo pong lahat, magandang hapon. Maraming salamat. The COMELEC is fully supportive of any measure that will finally institutionalize the anti-political dynasty provision of the Constitution. There's no question about that. Susuporta po kami 100%. Kung kaya nga lang po, sana bigyan niyo po kami ng ilang minuto lang maipaliwanag yung mga magiging problema ni COMELEC if there will be a law such as this, especially on the enforcement and implementation. Lagi naman po yun ang problem. Yung crux of the controversy is in the enforcement and implementation, perhaps because they failed to realize na hindi ganun kadali na ipagpatupad. But we have to push for this bill at all costs, and we honestly believe that this 20th Congress will definitely pass this very important piece of legislation. The law or the bill must be brief, broad, and definite. Kindly please do not allow the COMELEC to have that leeway in the interpretation of the law that you will be making. That will be problematic. That will be brought to the Supreme Court. Your law may not be questioned before the Supreme Court, but our IRR may be questioned before the Supreme Court. And therefore, even if we speed up the process of passing, but if we will fail to really see what is the intent of Congress, we will be charged with grave abuse of discretion amounting to lack or excess of jurisdiction. Hindi rin namin po maipapatupad. So dapat po brief, broad, definite. As much as possible, the COMELEC will not be left to interpret what is your desire as provided in the provisions of the law. Ngayon po, we would like also to emphasize that there, as previously cited by Congressman Jokno, there were two legislations already institutionalizing the anti-political dynasty. First, the SK Reform Act. Napakadali po namin na ipatapod yun ng 2022 barangay and SK elections. Bakit? Naging napakaliwanag po kasi sa COMELEC. Sino ang disqualified? Sino ang mariretain? Sabi po ng SK Reform Act, ang disqualified yung candidate sa Sangguniang Kabataan. Basta meron siyang relative by second degree sa national, provincial, regional, city, municipality, barangay, na incumbent, disqualified si SK. Simply because perhaps hindi magkasabay yung eleksyon ng SK at saka yung other candidates. So it's very easy because you have an incumbent to be the basis of who will be the dynast and who should be retained. Doon po sa Bangsamoro, of which the COMELEC was able to help in the drafting of the election code, including the IRR. Ang disqualified po doon ay yung pong second degree relative ng isang nominee sa parliament. So meaning to say, nilimit nila sa parliament. Ibig sabihin po, doon po sa kanila kasi, yung political parties will be required to submit 40 nominees. Sa 40 nominees na yon, kinakailangan hindi sila related sa bawat isa, up to the second degree. Pero may problem, hindi naman sila nagsabi na dapat hindi related sa chief minister o dapat hindi related sa representative ng parliamentary district. Limited lang sila doon sa nominees ng mismong political party. So they will have to submit to us 40. Pag meron siyang up to second degree, disqualified yung parehas. So ganun po ang kanilang provision sa kanila pong Bangsamoro Electoral Code. So very definite and therefore very easy on the part of the Commission on Election. Dito po sa problem natin, we will never interfere sa wisdom ng Congress. Yung issue po ng degree of relationship, that's an absolute discretion of Congress. Doon sa issue, well, it's simultaneous, magkakasunod ba o sabay-sabay, that's the discretion of Congress. But there are certain realities, perhaps, na sana po maunawaan nating lahat. For example, meron po tayong desisyon, the case of Peñera versus Comelec. Sa case ng Peñera versus Comelec, sabi ng Supreme Court in 2009, interpreting Section 14 ng Republic Act 9369, all of you are candidates only at the start of the campaign period. Sino po ba ang ating gustong i-disqualify dito? O i-cancel ang candidacy? Yung po bang kandidato o yung po bang na-elect na kandidato? Magkaiba po ang implication. Sapagkat kahit mag-file kayo ng candidacy na October, tapos candidate pa pala kayo by February sa national position or March sa local position, hindi pa po candidate. How do you disqualify somebody who is not yet a candidate? So, yun po yung isang issue na dapat sana ma-resolve ng kagalang-galang na committee na ito. Yung pong issue ng pre-election ba ang disqualification or post-election ba ang disqualification? Therefore, mukhang kakailanganin po natin na baguhin din yung provision ng Republic Act 9369 on when a candidate is a candidate under the law and under the decision of the Supreme Court in the case of Peñera versus Comelec. Kasi useless po itong usapan tungkol sa issue ng dynasty kung hindi natin alam kailan namin sila i-disqualify. And may problem po kami. Meron po kayong sa lahat po ng 21 bills, magkakaiba po ang remedies na ino-offer ng bawat isa. Tingnan niyo po, ang ginamit ng iba, disqualification. Ang ginamit ng iba, cancellation. Magkaiba po ang implication ng disqualification at cancellation. Baka po kasi expectation, tanggal yan. May problema po tayo. Pag po cancellation of candidacy, yan po ay nakalagay sa Section 78 ng Omnibus Election Code. Ano po yun? Material misrepresentation. Material misrepresentation of a fact which under the law should be declared by the candidate. And what is that fact? Section 74 ng Omnibus Election Code, the contents of the certificates of candidacy. Siyempre po, doon sa contents of the certificates of candidacy, wala namang political dynasty doon. So ano pong gagawin po ba natin? Kung magkakaroon ng batas, are we going to likewise amend Section 74 of the Omnibus Election Code to include that as one of the contents of the certificates of candidacy? Kasi po kung hindi natin lalagyan nun, yung ginawa po nung sa SK Reform Act, wala pong nilagay kung paano gagawin. Kaya si Comelec na pilitan, gumawa po kami ng oath that will be sworn to by the candidate. Sinabi niya, wala akong kamag-anak kahit isa. Para kung sakali na may madiscover na kamag-anak, kami misrepresentation ka. But that can be questioned by the candidate himself. Bakit? Pwedeng sabihin ni kandidato, in good faith ako, wala naman akong alam na tumatakbo pala yung isang kamag-anak ko. Whether national yan, parehas na national ba, o isang local, isang national, isang local, parehas national, parehas local, nasa Congress po yan. Pero, good faith is a defense and therefore there can be no misrepresentation. And what if the candidate will say, yes, may tumatakbo ako, kaaway ko na kapatid na doon sa kabilang bayan.
And therefore, walang misrepresentation, so to speak. So how do you disqualify or cancel a candidacy na wala namang misrepresentation? Kasi ang sinasabi na Section 74, he lied. You are canceling the candidacy because he lied. You are not canceling the candidacy for lack of qualification. Wala po tayong remedy to question the lack of qualification prior to the election. Yung issue ng citizenship, residency, registration as a voter, literacy, yan po lahat ng yan ay mga qualification to the office, 5 qualification to the office, but which absence any is not lack of qualification but material misrepresentation. Bakit ko po dinidistinguish? Kasi iba naman po ang disqualification. Ang disqualification, lahat ng sinabi kong yan na andyan, present lahat yung qualifications na yon. Kung kaya nga lamang po, nag-commit siya ng isang violation, for example, vote buying. Disqualification po yan. A disqualification case can be filed 25 days, anytime after the filing of the candidacy before the election. Yung pong cancellation na ginagamit din sa mga bills natin can be filed 25 days after the election. So magkaiba pala effect. Magkaiba po pala. Kung ang ginamit natin disqualification, pwede ka pang file yan up to noon of election day. Kung ginamit nyo pong wording sa cancellation of candidacy under existing laws and jurisprudence natin, 25 days lang po yan. So dapat din pala sigurong baguhin yon kung sakaling maipapasa natin ito. Ano po ba talaga? Cancellation or disqualification? Meron pa pong pinakamas serious na effect which will practically render inutile your anti-political dynasty bill or law later on. Substitution of candidates. Can a dynasty be substituted? Dapat po mailagay din siguro yon. Kasi otherwise po, kung hindi, everybody can be substituted. Anybody can withdraw for a particular period. Hindi po ba pag nag-file kayo ng candidacy ng October, usually nung nakakarang election, December, itong nakarang election, November namin inimpose yung deadline. Meaning, kung nag-file ka ng candidacy, walang nag-file ng disqualification case sa'yo o cancellation, your name will remain in the ballots. And therefore, kung may mag-file man, na-realize mo mukhang may talo, you can be substituted. So should we allow substitution of somebody who we believe is a dynast under our definition, under the definition provided for by Congress? So meron pa pong mas komplikado na sitwasyon. May recent decision ng Supreme Court, the case of Maungadatu versus Comelec. Ano po yung case ng Maungadatu versus Comelec? In that particular case, the Supreme Court, last year lang po yan, made a very important pronouncement reversing an age-old doctrine of the second placer rule. Alam po nating lahat, kapag ka ang final ay cancellation of candidacy, kapag ka na-cancel ang candidacy after the election, nanalo na after the election, ang pinapaupo kahit ng Supreme Court ang second placer. The Supreme Court abandoned the second placer rule. This time, the Supreme Court said whether disqualification ang i-file or whether cancellation ang i-file, the effect should be the same. The rule on succession should be applicable. Eh bakit po importante sa atin sa political dynasty discussion yan? Eh kapag po yung tumakbo vice mayor, ang sinabi po natin, parehas na position lang ang prohibited. Parehas ng local pero parehas na prohibited. Yung asawa tumakbong vice mayor, hindi po yung parehas na posisyon. And therefore, kung na-disqualify po o kinancel niyo yung candidacy ng mayor, after the election na mariresolve ni Comelec, ang uupo rin si vice mayor. O di dynasty pa rin po yun. Hindi po ba? So medyo pag-isipan po natin yung mga ganong klaseng implication because it would appear that there are several provisions of the laws, of our existing laws, that we should amend in relation to the anti-political dynasty. Meron pa pong isa pang problema. We have to understand that ngayon po ay almost 1 year and almost 6 months na lang filing na ng candidacy for the 2028 important election. So practically po, ganyan na lang po kaiksi yung pinag-uusapan natin na period para po maipasa natin itong anti-political dynasty because this will have to be implemented and enforced by COMELEC in 2028. So medyo may problem po tayo doon sa period. Sana po kung talaga maipapasa, sana po yung period hindi because we have to properly inform our electorate, our voters on this new law. Yung voters education po kasi is very, very important.
the duty of COMELEC is purely ministerial. Under Section 77 of the Omnibus Election Code, the COMELEC has no choice but to accept the certificates of candidacies of candidates. So kahit po alam namin, mukha namang Chinese to eh. O kaya naman po mukhang alam namin kapag anak to ni Mayor eh. O asawa, we cannot refuse accepting the candidacy. Ito pa po, naglagay po dun sa provision ng ilang bills that the COMELEC can motu proprio cancel candidacy. But even in the exercise of our motu proprio jurisdiction and power, we have to afford due process to candidates. Hindi po automatic na alam namin na yan ay kamag-anak, can cancel. Ang problem po natin, pag ganitong klase ng ground ng disqualification or cancellation, you need a full-blown hearing. You need to prove that this person is really related to the candidate, whether to the incumbent or pareha silang related. Sa amin po sa COMELEC, we receive thousands of cases. Try to imagine, Your Honors, if the filing of the candidacy is by October of 2027, the printing of the ballots is by even December of last week or first week of January, yun lang po yung period na ginagalawan ni COMELEC to resolve all of these cases. Iba pa po yung cases ng citizenship, disqualification, and such other grounds. Meaning to say, if we will be receiving thousands of cases, with all honesty, we will not be able to resolve cases. Makakatakbo po yung dynasty o makakatakbo yung may violation ng anti-political dynasty. Problem, tingnan nyo po, nangyari po ito recently, congressman. Sa congressman, after the election you are proclaimed and you have taken your oath even before a notary public, you are not yet members of the House of Representatives. Sabi ng Reyes versus COMELEC involving a congressman in Marinduque, sabi po ng Supreme Court, you become members of Congress only upon assumption to office, which will happen by June 30. So the COMELEC still has jurisdiction from your proclamation to your oath up to June 30 noon of election day. In which case, pwede po namin kayong tanggalin for having violated the anti-political dynasty. Question po, sino po ang papalit? Samantalang sabi po ng Supreme Court, there is no second placer and therefore there is no succession sa member of the House of Representatives. So ito po yung mga bagay na pag inisipan po natin medyo problem. Isa pa po, may nakita po kami bills, sinama po ang party list. That is actually, we are supporting that. However, may problem po tayo. In one case, filed by Bayan Muna, Palparan versus HRET. In the case of Abayon versus HRET, twin cases po yun. Ang tanong doon, who is the member of Congress? Is it the party list or the nominees? May pangalawang tanong po doon, who is the candidate? Is it the party list or the nominees? So unang tanong, who is the member of Congress so that you can apply the 3 consecutive term limitation? Sabi ng Supreme Court, the nominees are the members of Congress. Therefore, the qualification requirement as well as the 3-term limit is applicable to the nominees. Now, but who are the candidates? The candidates are the political parties or the sectoral organizations or the sectoral parties themselves. So ano pong ibig sabihin? How do we disqualify somebody who is a nominee of a party list when that nominee is not yet pala the candidate? If our purpose is to disqualify a nominee who happens to be a candidate who is actually related to a national or a regional or a local candidate. So medyo may problem po tayo. So we have to likewise change that. Because if our intention is to disqualify even the nominees, then we declare that the nominees are candidates themselves. So yun po isang problem din natin. Napansin din po namin doon sa inyo pong mga draft bills na hindi po naisama ang Bangsamoro. Nabanggit niyo po provinces, but Article 10 of the Constitution provides that local government units shall constitute the provinces, cities, municipalities, barangays, and the autonomous regions in Muslim Mindanao. So ano pong ibig sabihin? Meron po silang chief minister, meron po sila doon na members of the parliament. Doon po sa kanila ay 32 na ang parliamentary districts nila. Meron po silang 40 na members dapat ng political parties at meron po silang 8 na mga miyembro po ng sectoral organizations. Tanong po, kung sakali po ba dito sa ating pong mga proposal, idadamay din po ba natin na may violation ng anti-political dynasty even sa ating pong Bangsamoro? We should not exclude any position because that will violate the Equal Protection Clause. of the Constitution. So what we are saying po, baka po ang gawin namin, with all due respect and with all candidness, baka po ang filing ng candidacy namin will be by July of 2027. Mas i-advance po namin so that we will be able to resolve cases. Take note po, we experienced something. Dumating po kami sa point, nung nakaraan, kung natatandaan po ng lahat, nag-disqualify po kami ng lahat ng nuisance case candidates. Wala po kami, zero po kami sa nuisance candidates. Kaya lamang po, may isang pumunta sa Supreme Court, nakakuha ng TRO, we were already printing 6 million ballots by January 3rd week. 6 million na po nakakuha siya ng TRO. We have to stop the printing of the ballots. So yun po yung gusto namin. Kasi kung may papasok na bagong ground of disqualification, ay magiging problematic po. One last point po. Yung first to file, napakaganda po sanang proposal yung first to file. Unahan na lang. So alam po namin, isang araw pa lang pipilahan na yung COMELEC para lang makapag-file. Pero, are we encouraging nuisance candidacies? Ang problem po namin, madami po magpa-file ng mga kamag-anak ng nuisance candidates simply because binayaran sila o kinausap sila para lang maunsyami yung pagpa-file ng candidacy ng legitimate candidate. So yun lang po yung mga bagay na ilan pa sa napakadami. We are going to submit a comprehensive, extensive position paper on this. But the clear point po is ganito. We should not limit only, with all due respect, to the passage of this. Maganda po yun. We have to pass something. But likewise, please kindly consider the other provisions of the law. Simply because if we will not properly amend other provisions of the code, election code, and other election laws, hindi rin po natin ba ipapatupad ng tama ang ating pong napakaganda na panukalang batas na to ng political dynasty. So in the meantime, Your Honors, we're going to submit after this hearing our position paper on this and everything, yung pong mga iba pa, including an analysis of each and every authorship of your bills so that we will have comments likewise on these bills. We will not make a suggestion simply because we reserve that to the wisdom of the Honorable Congress. Maraming salamat po. Magandang hapon.
Mr. Chairman, I have some questions to the chairman. Chairman.
Yes,
First question is,
before we recognize po, just a few, Thank you, COMELEC, for that remarks. I believe you will submit a presentation, right? So I understand these are. Thank you for reminding us, no? But these are all reminders. There are existing rulings and policies covering election-related cases, which I believe the committee will be, this will be helpful in trying to navigate on how we can actually avoid a violation of any ruling of the Supreme Court so that we can actually come up with a more legally compliant, constitutionally sound anti-political dynasty. I know there are indications that some of the members would like to ask questions to the COMELEC because we have presented to us, several policies and rulings, etc. If kung pwede lang po, because we will be this is going to be a tough and masyadong po itong mga pag-usapan natin. If kung pwede lang po sa ating mga members, if we can just allow all the presenters to present.
Mr. Chairman, with due respect, the COMELEC chair will be leaving.
Yes.
So therefore, we'd like to ask him now before he leaves.
COMELEC, you'll be leaving, di ba?
Yeah.
But we will definitely be happy to entertain questions.
All right, very good.
Yeah, but will you be back today or
maybe not today? We're going to discuss the Bangsamoro parliamentary election.
Okay, now so do you have a representative who can actually respond to questions from the members?
We will be leaving our certain officials of the COMELEC. But we are willing to, Your Honor.
Okay, anyway, so ganito na lang kasi
Can
gusto
I
lang
ask-
okay, so for COMELEC only, I think kasi we would maximize na lang the time of our chairman here kasi lalabas po siya. So can we request all members, would you like to, if you want to ask questions to COMELEC, please register your name so that we can acknowledge you, no? So Congressman
I'll be the
Rufus
first.
Rodriguez, and then after that Congressman Edgar Erice, and then Congressman Romulo. And others, please signify po Pakiregister yung pangalan. Yes, Congressman Rufus Rodriguez.
Thank you, Mr. Chairman. So my first question is the question of the chair. How do you reconcile limitation of relationships in a dynasty to the right of persons to run for public office and for the people, for the voters to vote for candidates? That's the first question. What is your stand on that? Is there no conflict? Is there a conflict? Which prevails? The people's will or our prohibition of dynasty members?
Thank you very much, Mr. Chair. In the case of Arwego versus the COMELEC, the Supreme Court clarified, Mr. Chair, that before the election rules should be strictly interpreted. But after the election rules should be liberally interpreted because there's already a mandate of the people. However, Mr. Chair, there was this decision of the Supreme Court in the case of Velasco versus COMELEC involving a mayor of Sasmuan, Pampanga. A petition to disqualify, cancel his candidacy was filed before the election. The case was decided only after the election. He won the election. And yet it reached the Supreme Court. The Supreme Court sustained the cancellation of candidacy, although he won the election. The Supreme Court said the will of the people cannot prevail over the rule of law. And the rule of law is, if he is disqualified from the very start, he is disqualified even if elected by the people.
Is there a conflict? The Supreme Court said so. Is there a conflict between democracy, the right of suffrage, and the right to be elected to public office, and prohibiting people because they are related in whatever degree to an incumbent or other candidates? What is the position of the chairman, being a very knowledgeable about election law?
The anti-political dynasty provision, although not defined by the framers of the Constitution, was included under Article 2 on the Declaration of Principles and State Policy. It is actually a policy of the state. The right of suffrage is under Article 5. In the hierarchy of articles, therefore, the Declaration of Policy is superior than any other after any other provision after the Article 2, Mr. Chair.
Thank you. Very reasonable. Second, you stated that there's a conflict between putting in the law disqualification or cancellation of candidacies in the case of dynasty, in case this will be passed. What is your suggestion? Should we place there disqualification of those related or cancellation?
Should be just a not a recommendation, but it should really be cancellation of candidacy so that there will be no substitution of candidates. Otherwise, Mr. Chair, what they are going to do is just file the candidacy. Somebody will be filing. If there will be no filers or no petition filed, then malalagay po yung pangalan sa balota, maboboto po eh. In fact, hindi ko pa po nabanggit what is the effect. Will the votes be considered stray or the votes be considered as valid after the election? So yung po malalagay kasi yung pangalan sa ang boto sa balota. In one case, the case of Tagolino versus HRET and Lucy Torres, the Supreme Court said the vote for Richard Gomez is the vote for Lucy Torres. Therefore, lahat ng boto kinonsider. So dito po ba are we willing to say that after the election the votes should be considered also to the other candidate? So yun po yung isang problem.
Chairman, in the case of Codilla versus Gomez, I was one of the members of the HRET. Precisely that ruling was abrogated by the Supreme Court. We were reversed. They were reversed. I was the only dissenting opinion. Because the Supreme Court ruled that because Richard Gomez was not qualified, Lucy Torres cannot replace a disqualified candidate because of residence. So therefore, when you talk about dynasty, a person who is disqualified because of that dynasty cannot be substituted. That is the ruling of Codilla versus Gomez. Where I was the HRET, I was the only lone dissenter that the Supreme Court ruled in favor of Gomez. I was for Codilla because I saw that, the spring cannot rise over its source. And since Richard Gomez at the time was not a resident of Ormoc, then Lucy Torres was disqualified. Now, the only thing is, he was disqualified 4 months before the election. And so therefore, it was an empty victory for the Codilla because Lucy Torres stayed on. And because of that case, Lucy Torres went to to Congress 4 times because he was disqualified in the first time.
So,
You see?
Mr. Chair, it should
So
be-
Lucy Torres is very happy with me, including Richard. But that is the point. So no need, therefore, because under the case of Cordelia versus Gomez, a person disqualified because of dynasty cannot be substituted because originally the person who was fired is already disqualified. Now, next question, Mr. Chairperson. No? The next one is about the second place rule. Okay, so you do not agree with the Supreme Court.
We did not file a motion for reconsideration.
Of this, because the Supreme Court or the Supreme, they are the supreme in their mistakes.
We did not file a motion for reconsideration because we were sustained by the Supreme Court on the cancellation of the candidacy of the opponent of the wife of Congressman Toto Mawadato. But however, we did not file a motion for reconsideration as regards the issue of the abandonment of the second place rule. But I think the petitioner there filed a motion for reconsideration on the issue. So, hindi na po importante, but we support the Supreme Court and therefore whatever the Supreme Court will say, we'll just implement, Mr. Chair.
Probably another case will come and, they can also change, in the next decision. Lastly, because others will have questions, so you suggest that our bills on anti-dynasty should include the BARM, correct? So that not only, like for example, the BARM prohibition is only in the list of parliamentary sila eh. We are presidential. So therefore, you suggest that we include the BARM as part. Kasi naka-enumerate in most of these cases are national, provincial, municipal, cities, barangays. So you suggest to have the BARM included in this dynasty bill?
Yes, Mr. Chair, simply because under Article 10 of the Constitution on local governments, autonomous regions are part of the local government.
Thank you very much.
So, very satisfactory, excellent answers of the excellent chairman of the Commission on Elections. Thank you.
Before I call on to, I recognize the next interpellator. I'd like to go back to the BARM issue, Chairman Garcia. Let me, help me understand, kasi there was already a ruling by the Supreme Court. I think it's Kedah versus DPWH, and this covers about the implementation of the regional laws enacted by the Regional Assembly. So insofar as the implementation and the territory of the scope of the law passed by RLA, if there's a conflicting law passed by the House, the supremacy of these laws would really determine the scope and the territory by which it will be implemented. So therefore, the regional law supersedes the national law. So can you, if the position of COMELEC is to include the BARM, because they already also been given the power to enact their own laws. So that's why we have the IGRB, the Philippine Congress, Bangsamoro Parliament, Legislative Forum, so that we can actually reconcile, harmonize bills enacted by the Parliament and by the national legislature, in this case, the House of Representatives. So can you help me on that?
Thank you very much, Mr. Chair. When it comes to matters pertaining to the territory, subdivision of the territory, it is an absolute discretion of the Bangsamoro Parliament, and that is included under the organic law of the Bangsamoro. But when it comes to the fixing of the dates of the election, when it comes to the issue of political dynasty, simply because it is a national in scope, specifically provided, as I mentioned, under Article 2, then the national laws will always have to prevail over the local legislation. So yung po talaga yung hati. Yung pong parliamentary districting, sa kanila po yun. Yung pag-elect ng mga sectoral organizations, whether elected or by assembly, sa kanila po yun. Yung 40 seats, ngayon, plano nilang baguhin for 4%, halimbawa, gagawin nilang 2%, absolute discretion po nila din po yun. But when it comes to the implementation of national laws or national policies and principles, that's only for Congress to determine under the police power of the state.
Thank you, COMELEC. Now we recognize the next member who would like to ask questions, Congressman Irise.
Yes, actually, it's not a question, it's a request. Maybe the COMELEC can dig deeper on the implications of, for example, because there are proposals for prohibition on the second degree and fourth degree. Ang aking pong question dito yung enforceability. So pwede po kayo mag-submit yung Commission on Election ng isang mas malalim na pag-aaral sa enforceability ng second at third degree at kung ang gagamitin dito ay cancellation o disqualification para pong comparative data sa enforceability nitong dalawang version na ito.
Yes po, Mr. Chair. And in fact po, ang position ng COMELEC, any determination as to what degree should be data-driven. Meaning yung pong Ateneo already had a study and they already had the data as regards to whether it's second degree, fourth degree, third degree. So maganda po data. But we will be submitting our position on that, Mr. Chair.
Thank you.
Thank you, Boss Egay, Congressman Erice. Now, we recognize Congressman Romulo.
Mr. Chair, actually manifestation lang sana, but I just want to clarify from the chairman, yung response niya kay Honorable Rodriguez on the first query with respect on the weight of the right to vote, the right to run versus political dynasties. Ano sagot niyo ulit po doon?
It is my honest belief that the right of voting should also bow to the basic principles and declaration of policy enshrined in the Constitution because po yung declaration of policy practically covers all.
Yes, but that begs the question. Please read Article 2, Section 1. It says, what does it say, Mr. Chair?
Sovereignty resides on the people
Correct.
and all
The
government
democracy.
authority.
And that democracy is important. So yung sagot po ninyo baka hindi tama. Kasi Section 1, Article 2 of the Constitution says, sovereignty resides in the Filipino people and all government authority emanates from them. So siguro kailangan pag-aralan pa yon. Pangalawa, I agree with Honorable Erice, dapat tama ho kayo kanina kasi kayo may alam kung ano yung mga problema because you implement election laws. So tama po yun. Kung pwedeng bigyan nyo kami ng suggestions on how it will become implementable for the COMELEC once we have an anti-dynasty law. Pero kanina may sagot po, may comment kayo na medyo gusto ko lang liwanagin. Sinabi ninyo may issue kayo dun sa SK law about you asked them to issue a certification?
Oath, Mr. Chair.
An oath that wala silang relative?
Yes, Mr. Chair, simply because the law did not tell the Commission on how to implement the anti-political dynasty. So what the COMELEC did was to require the SK candidates for an oath and therefore para lang po pumasok yung misrepresentation, Mr. Chair. Otherwise, kung wala pong oath, walang misrepresentation.
Yes. But Mr. Chairman, in addition to that, sinabi ninyo, yung medyo challenge sa inyo doon, pag biglang may sumulpot na kamag-anak, sasabihin sa inyo, good faith.
Wala naman po kami na-experience na gano'n dito sa mga disqualify namin, Mr. Chair. But a good lawyer will always find something in order just to as a defense mechanism para lang po hindi ma-cancel or ma-disqualify. Because po...
And good faith is one of them.
Because, Mr. Chair, yung po kasing Section 74, in relation to 78, good faith may not be a defense because titingnan nyo lang po yung yung enumeration ng Section 74. Pero kung wala po sa enumeration ng Section 74, contents of the certificates of candidacy, pwede po kasing ma-raise yung issue ng good faith. Although,
Yes. Section 74 that you're referring to refers to a special law?
Yes, Mr.
Yes,
Chair.
hindi ba, principle natin that good faith only applies to violation of RPC provisions, not the special laws, unless specific sa special law?
Yun po kasing Section 78 in relation to 74
Opo.
carries with it not only administrative, civil, but
Yes.
likewise criminal.
But it's a principle under any criminal
Yes,
law
sir.
that good faith is only a defense kung RPC ang violation mo. Kung ang violation mo hindi RPC, it's a special law, unless stated specifically in the special law, hindi defense ang good faith.
Yes,
Correct.
that's my... Ganito po,
That is
Mr.
correct.
Chair. The Supreme Court already sustained consistently kapag po may violation ng Section 78, which is material misrepresentation, in relation to 74, the candidate is not only liable for cancellation of his candidacy, but likewise, it is a criminal case. That's why po yung lahat ng mga pinapailan sa amin, kahit nakaligtas sila ng mga kaso ng cancellation, meron pa rin po kaming jurisdiction to conduct preliminary investigation and to charge candidates with material misrepresentation.
Yes, but I suppose kung meron kang, kung maiugnay mo yon sa violation of an RPC provision, tama kayo, baka na-relate yun. But I think you should question that because very clear sa atin, that is a principle in law that was taught in all law schools, na pagka-special law, hindi dapat mag-apply ang good faith.
Except dan po, Mr. Chair, if the law per se provides for prosecution. Yung pong
Yes.
Section 261 ng Omnibus Election Code, nag-enumerate po, nakasama po kasi doon, that violation of Section 78 in relation to 74 is criminal. And
In
therefore,
that case, Mr. Chairman, ang dapat ninyong sabihin sa amin ay katulad yung difficulty na yon. So this new special law that we will pass, ma-exclude namin yung mga ganon. And that is the point. Hindi yung, tama po kayo eh, kayo ang may alam eh, kung ano yung difficulties that you went through. But what this committee needs is your advice on what we should do, how to craft it, para yung technicalities ng batas, hindi nyo na dadaanan ulit. Kasi sa totoo, gusto niyo rin naman po ng anti-political dynasty law based on your response to Honorable Rodriguez na based on the hierarchy, dapat mas mataas siya. But I disagree with that because of Article 2, Section 1. Pero if that is your point of view, tulungan niyo na lang kami dito sa difficulties niyo. Instead of giving us one by one lahat ng challenges, isabay niyo na rin doon kung ano yung pwede ninyong masuggest na ipasok namin sa proposed law para mas madali rin para sa COMELEC.
Definitely, Mr. Chair, we will be doing that, except that gusto lang po namin emphasize, there are certain matters which are exclusively reserved to the wisdom of Congress, and the COMELEC does not want to really interfere, such as do we include, yes, do we include a penal clause, for example, if somebody will be proven to be a dynast or will violate the anti-political dynasty law, will that be criminal, and therefore, so that the COMELEC can likewise have jurisdiction, will that be considered as an election? We will include that also. But just a caution, Mr. Chair, that is just a mere suggestion without carrying any whatever weight should be as far as the members of Congress is concerned.
Thank you, Chairman. Thank you, Chair.
Mr. Chair.
Thank you. Thank you, Congressman
Mr. Chair.
Romulo. Yes, if it's
Briefly.
germane to the
Yes,
issue.
very germane.
Okay, with,
Very germane. Completely
okay, thank
germane.
you. Yes, Congressman Kimbo.
Mr. Chair, I have utmost respect for my much older brother, Congressman Roman Romulo, but I vehemently disagree. And I support the position of the chairman of the COMELEC. It is correct. Article 2, Section 1 states very clearly, sovereignty emanates from the people. But the people's right is never absolute. That's why when you look at the Bill of Rights, it is replete with limitations to the exercise of rights. Even your right to freedom, your right to liberty, more so your right to suffrage, can be limited. And the state policies in Article 2 is prevailing. So I want to put that on record because otherwise, if we accept that, then that means we cannot put any prohibition or limitation on the right of people to vote and to be voted upon. So I'm just respectfully disagreeing, Mr. Chair.
Thank you for your opinion. Thank you for your opinion. Yeah, thank you for your
Just to respond,
Okay.
I fully respect, and my only point in mentioning that was the chairman of COMELEC said that because of precedents based on the sequence and declaration of policy, para sa kanya, definite siya na nangingibabaw yung right to pass an anti-dynasty law. Ang point ko lang, hindi dapat yun yung reason. There must be a good reason, but that is not the reason because we still have Article 2, Section 1 of the Constitution.
Thank you, gentlemen, for your
last point,
points.
Mr. Chair. I promise, last point.
Okay.
I agree with Congressman Romulo. So when you apply the hierarchy of rights, it applies to the Bill of Rights alone. Meaning from the first section all the way down, that's the hierarchy that you apply. But as far as Article 2, relative to Article 3 is concerned, they are separate in terms of interpretation. But when you want to utilize a conflicting set of rights, you will have to look at the hierarchy relative to just Article 3 alone. Thank you, Mr. Chair.
Thank you. Are you gentlemen done with your your legal? Yeah, I understand. Yeah, and thank you for all those points. Again, COMELEC, we would request you, again, COMELEC, to submit to us your position papers, including the request of Congressman Romulo to include all the, all the implementation of all these rulings in election-related cases, so that we can also know how to provide special provisions or sections in the proposed substitute bill that will come up by this committee. So ganun lang po. Thank you very much, gentlemen, for your questions. Thank you, COMELEC. Now, we recognize Congressman Garbin to ask questions to COMELEC.
Thank you, Mr. Chair. Now, I fully support the anti-political dynasty bill in broadening of political participation and limiting the concentration of powers sa nagkakailang pamilya lamang. And in doing so, we need to really come up with this. Yeah, I was the last beneficiary of the second placer rule, wherein the COMELEC and Bank upheld the decision, was upheld by the Supreme Court decision. I was listening to the chair of the COMELEC, and he said that in doing so, we need also to harmonize the provisions of other laws and the Constitution. Comes to my mind, Mr. Chair, that there are constitutionally fixed qualification in the Constitution, particularly Article 6 and Article 7, the qualification of the President, the Vice President, the Senate, and the House of Representatives. And in long line of cases decided by the Supreme Court, the mere, addition of qualification by ordinary legislation was declared as unconstitutional. Meaning, can we adopt an ordinary legislation that will override a constitutional fixed qualification mentioned under Article 6 and under Article 7 of the 1987 Constitution? Sa atin, dito sa Kongreso, natural-born citizen, 25 years of age, able to read and write, a registered voter of the district. Ito ba yung question because can an ordinary legislation override those specific qualifications mentioned under Article 6 and under Article 7 of the 1987 Constitution? These are national elective offices of which their qualification is fixed and categorical under the said provision, Chairman.
Thank you very much, Mr. Chair. That's why po, Mr. Chair, our initial statement was that the best remedy should be cancellation of candidacy. Because in cancellation of candidacy, it does not refer to the qualification to the office. Although, indeed, you are mentioning citizenship, residency, registration as a voter, literacy, and age, but just the same, sabi po ng Supreme Court, pag Section 78 and cancellation, hindi naman dahil wala siyang qualification, but because he lied. He misrepresented himself in a material fact. Samantalang kung ito po'y disqualification, it may refer to an additional qualification which Congress cannot do because the Constitution, as you have mentioned, Mr. Chair, fixed already the qualification, basic qualification to a particular office. As mentioned po kanina sa isang speech, Mr. Chair, the Supreme Court already said in one case, yung pong kaso ng Pimentel versus COMELEC, at saka po yung Dangerous Drugs Board case, nagdagdag po ang Congress, ang COMELEC mismo ng additional qualification, certification na hindi addict yung mismong kandidato. It was raised before the Supreme Court. The Supreme Court reversed the COMELEC saying that number one, that is an act of legislation. Number two, you cannot really put or add additional qualification to what is prescribed by the Constitution.
So in that case, Mr. Chair, ano man ang gawin namin dito sa Kongreso, defining anti-dynasty bill and coming up with additional disqualification, which would permanently be an additional qualification, would only cover local elective official, meaning from the governor down to the SK, as what we did in the Bangsamoro Law and the SK Reform Act. Now, to cover national elective of offices or official, it would entail amendment to Article 6 and Article 7 of the 1987 Constitution, because as I've mentioned, these are constitutionally fixed qualification in those two articles. Would that be correct,
At this point, Mr. Chair, I'm not yet in the position to answer. It may be legally correct, but that will intrude into the wisdom of Congress that I have mentioned, because that will now be, my answer will now be an answer to whether it should be a national or a local dynasty disqualification. So, hindi na lang, isasama na lang po namin doon sa position paper, Mr. Chair.
Ang kakilaman po kasi dito, Mr. Chair and Mr. Chairman, that whenever we introduce reform, that reform should be constitutional, totoo at enduring. Hindi tayo pwede pumasa dito na pagdating sa Korte Suprema ay dideklara lang as unconstitutional. I'm speaking of members of the House, the Senate, and those who will be running for President and Vice President. Thank you, Mr. Chair.
Mr. Chair. Thank you very much. We have a list here. Thank you very much, Congressman Gerbin. Is that germane to the issue of Congressman
Mr. Chair,
Gerbin?
in connection with
In connection, okay, please.
Yes.
And i-recognize na rin kita ngayon kasi hindi kita na-recognize kanina sa 4th District, Quezon City, Congressman Bong Suntay. Please, sir. Congressman.
Mr. Chair.
Okay.
Well, actually, I do not actually see any conflict, even if we pass an anti-dynasty bill. In fact, it reinforces a constitutional mandate. The provision on Article 2, Section 26 of the Constitution, which states the 1987 Constitution explicitly provides that the state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law. So what we are doing is strengthening that provision and implementing that provision. We're not adding any additional requirement. We're implementing Article 2, Section 26. There's no conflict. In fact, it reconciles the provisions.
Thank you, thank you. Yes,
just to
maybe,
answer.
yes, maybe last. And understand, gentlemen, that we have different interpretation of this law, of these measures. We have sometimes conflicting ideas. But maybe just one response, so that we can not consume too much time. We would like to hear from our resource persons. Yes, Congressman Gerbin. Yes.
As I've said, we are all in support of this anti-political dynasty bill. But what we want is a reform that is real and eventually will be declared by the Supreme Court as constitutional. Now, Article 2, Section 26 is a state policy but not self-executing. It is an intent, but it does not override existing provision or constitutional command, such as I've mentioned in Article 6 and Article 7. So, yan lang po ang akin dito.
Thank you very much, Congressman Gerbin, for that. Now we move to the last interpolator as far as COMELEC is concerned. Congressman Brian po.
Thank you, Mr. Chair. Given the fact that this will most likely be...
Yes, gentlemen. May we allow Congressman Brian, may we listen to Congressman Brian's question? Please, gentlemen, yes. Please proceed.
Yes, given that this is probably going to be the most important electoral reform law that we will pass within our time, it is not something that we can summarize in 3 or 4 questions to COMELEC at the moment. Even if COMELEC were to submit a position paper to us, we would most likely go back and forth quite a few times on that position paper. My suggestion is similar to what we did with EDCOM, that we form a technical working group with as many members of the private sector present and civil society, so that outside of this committee hearing, which we probably only have 2 more hours before session, we will be able to continue to deliberate the provisions because it affects the ability to run for office. As important as the right to vote is the right to run for office. So we cannot summarize that in a few questions in a few hours. This is something that we need proper representation on. Kaya para sa akin, may mga tao na gusto pumunta dito, pero because of important business outside, they were unable to attend. I suggest that if the chair would be open to it, and many other members here, that we also form a technical working group outside of this to create a report similar to EDCOM to inform a very important law that we will be passing.
Thank you for that suggestion. In fact, that's one of the things, one of the options that I guess the chair would like to proceed on, as far as consolidating all the 20 versions of the bill. But we will hear first, and we will be holding another hearings. This will not be the last. We compartmentalize all the guests, and we would like to approach this thematically, meaning legal issues, and so other CSOs would have the part of the agenda to support this measure. But we can guarantee, we can ensure and assure Congressman Llamazares that those are one of the options that we would like to look into, maybe probably create a TWG. So any other, maybe mamaya na lang.
Mr. Chair.
That's all. Thank you, Mr. Chair.
Thank you.
Mr. Chair, just a clarification, just a question.
Yes, what's the clarification?
On the internal proceedings. Has there been a matrix made on
Yes.
on all 20 bills,
Yes,
pointing out the differences as to four, because I could see
Yes.
four issues here: the degree of
We-
relationship, the substitution, the simultaneous holding of positions, and then how many
Yes.
candidates would
We
be.
already printed out the matrix differences and the similarities of all these 20 measures. That's actually attached. We attached that to the notices, and we sent those. Here we are. We sent the copies to your emails. If you can run through your emails, makikita niyo po yan. Para po, but there are two additional bills nga po eh. Just na-refer lang po, na-mention lang po kagabi, yesterday. So we are also anticipating another referral of two additional bills of similar subject matter. So we would include that later po sa final matrix ng presentation ng committee po.
Thank you.
Thank you. So now, Comelec, do you have to leave na, Commissioner? I'm sorry, Chairman. Sorry, nadimutan. Chairman, do you have to leave na?
Yeah, if the honorable
Yes.
committee will allow, Mr. Chair.
Maraming salamat po, and hopefully makapunta po kayo next hearing po. We will send
Yes,
another
Mr.
invitation
Chair.
po.
Thank you very much po.
Thank you,
Maraming
Chairman
salamat.
George Garcia. God bless po. So maybe for the next guest, we'd like to ask Attorney Lee Edson Garcia from the Institute representing the UP College of Law. Asan si Kong Miro? He's a senior legal associate from the Institute of Government and Law Reform.
Chair,
Yes.
Mr. Chair.
Yes, continue.
Thank you. Before the resource persons, I understand these are law experts, law deans, and on the list there are also supposed to be justices or former justices. Earlier in your preliminary to introducing the resource persons, you posed certain general
Questions. Yeah.
questions that would serve to delineate the scope and bounds of the discussion, no? And I would just like to add a question that hopefully as some or at least some of the resource persons may also speak to. In particular, the constitutional provision or the constitutional mandate, that's Article 2, Section 26, states that the state shall guarantee equal access to opportunities for public service. Okay. And generally, I mean, if we look at all the bills, that the mandate is seen to only apply to elections. No? That's why, for example, it is the Committee on Suffrage. that is discussing this bill. All the bills, including our own, limit the prohibition against political dynasties to elective posts. Now, I would just like to pose a question. Does the constitutional mandate prohibiting political dynasties only apply to elective positions? Because what it says here is that the state shall guarantee equal access to opportunities for public service. Now, opportunities for public service are not limited to elective posts. So, baka pwede po may magpaliwanag lang why, for example, the constitutional mandate does not or should not extend to, for example, appointive positions. No? So, and in fact, if I may just add that the immediate context of the 1987 Constitution was the conjugal dictatorship of Marcos and Imelda, diba? Where okay, you had a president, a dictator, but you also had the wife who was appointed to powerful positions in government as well. No? And so, yun lang po, Mr. Chair. Could that question be addressed as well? Limited lang ba sa elective positions ang prohibition on political dynasties na minamandato ng konstitusyon, or dapat bang saklawin din pati yung mga appointive positions? Kung hindi, bakit hindi? Yun lang po, Mr. Chair.
Thank you. Well, that's precisely why we want to listen to the resource persons, because there's
Yeah,
some questions.
Mr. Chairman, we would like to, that's a very good question, but we reserve questions because we only wanted the COMELEC to answer before they leave. But now, let us hear first all the resource persons, and then all of us can ask questions. And of course, the question of Congressman Tino will be the first one that will be answered by when everybody is finished on the resource persons. Can we now hear the resource persons, Mr. Chairman?
Thank you. Congressman Tinio will allow the resource persons to proceed. Attorney Garcia.
Good afternoon, Mr. Chair, Your Honors, colleagues. We thank the committee for inviting the University of the Philippines College of Law for the opportunity to contribute to the discussions on the passage of the Anti-Political Dynasties Law. The UP College of Law strongly supports the immediate passage of the Anti-Political Dynasties Law. Our studied opinion and informed by our multi-stakeholder consultations through an Anti-Political Dynasties Forum is summarized as follows. Number one, the prohibition of political dynasties is a constitutional command and is an integral component of all laws, rules, and regulations on public service. Article 2, Section 26 is read into our legal framework. It is our opinion that defining political dynasties is not tantamount to adding a new requirement to holding public office, as the constitutional command prohibiting political dynasties has been a condition for public service since the birth of our constitutional framework in 1987. Notably, Article 2, Section 26 uses the phrase political dynasties as may be defined by law, which is different from the other provisions in the Constitution, which uses the language as may be provided by law. As such, it is our position that only the definition is left to the wisdom of the Congress, not the prohibition itself. We also note that there was in fact a motion during the constitutional deliberation to delete the prohibition on the ground of the absolute right of the people to vote and of candidates to run for public office. This motion was duly considered and debated and ultimately defeated, holding the primacy of the prohibition against political dynasties over the absolute right of the people to vote and of the candidates to run for public office. The Filipino people ratified this provision, carrying the intent of the framers to give primacy to the prohibition and we presume that the people are fully aware of the deliberations made by the Constitutional Commission. Notably, the Constitution also limits the right to vote and the right to run for public office by providing conditions such as citizenship, age, residency, among others. The prohibition of political dynasty is a similar constitutional limitation, mandate, and command. Number two, the scope of the prohibition should cover both simultaneous and successive holding of public office. In academic language, the prohibition should extend to both thin and fat dynasties. Ito po ay pagbabawal ng sunod-sunod at sabay-sabay na paghawak ng pampublikong posisyon ng dinastiya. Our opinion is based on the records of the Constitutional Commission, which aim to address the problem of guaranteeing equal access to public service with a strong conviction to end the practice of inheriting public office. In addition, the framers of the Constitution also aim to address the problem of graft and corruption that is a result of families holding positions of power at the same time. Recent studies confirm these concerns raised in 1986. Political dynasties are linked to underdevelopment, high incidence of poverty, graft and corruption, and weakening of the rule of law. It also leads to voter apathy and lack of interest in democratic participation. To address these issues, both simultaneous and successive holding of public office should be prohibited. Number three, notably, the prohibition was meant to prohibit both elective and appointive offices. In response to the question of Representative Tinio, the original text of the constitutional provision actually proposed the text public office. But upon the motion of Commissioner Davide, the text was amended. What was adopted was public service. And the explanation in the constitutional deliberation was an express intent to cover both elective and appointive offices. Number four, the degree of relationship may be based on existing statutory and constitutional provisions. For example, Republic Act number 6713, or the Code of Conduct and Ethical Standards for Public Officials and Employees, defines relatives as within the fourth degree of consanguinity or affinity. Republic Act number 10742, or the Sangguniang Kabataan Reform Act, uses second degree of consanguinity or affinity. The 1987 Constitution prohibits the appointment of president's relatives within the fourth degree of consanguinity in certain public offices. It is our position that at the very least, the prohibition should extend to the second civil degree, but to also consider other statutory provisions that extend to the fourth degree of consanguinity. Finally, the Anti-Political Dynasties Bill should also include reforms to address voter literacy and empowerment, together with measures that address socio-economic issues in the country. The existence of political dynasties is a manifestation of weak democratic institutions that is linked to poverty. This new law should be seen as the first step towards achieving comprehensive electoral reforms in the country towards a broader socio-economic reform. Thank you very much.
Thank you, Attorney Garcia. You do have a study that you done, diba?
The UP College of Law hosted a multi-stakeholder forum, and all the studies were presented there, Mr. Chair. So we have studies from our constituent colleges, also from our political law experts, even also from the Ateneo School of Government.
But you have already done a study and may presentation kayo, di ba? Mayroon kayo.
Yes, Mr. Chair, I presented during the PLLO organized
so what
forum.
you read to us is just your position. But can we request for you for the presentation that you also, I believe you were attended last week or 2 weeks ago dun sa Novotel, and you presented a very conducted yung study ninyo, yung result ng study ninyo, there were illustrations and there were actually graphs. Can you submit to us those studies?
Chair.
Para marami daw studies ito eh.
We actually submitted that in also, but we will resend it to the
your
committee.
presentation. Thank you very much, Attorney.
Thank you, Mr. Chair.
So now we proceed to Attorney Catherine Alcantara, attorney from the Institute of Government and Law Reform.
Thank you, Mr. Chair. So, I am from the UP Law Center, Institute of Government and Law Reform, and we take the same position as the UP College of Law. The UP IGLR and the UP Law Center and the College of Law are actually part of one UP Law complex in the University of the Philippines. So, we represent one UP Law complex. Buong-buo po ang suporta namin sa pagpasa ng isang batas na tunay na magpapatupad sa utos ng ating saligang batas na ipagbawal ang political dynasties. Since we echo Professor Garcia's opinion as delivered, may we just add briefly to the points he raised. Since, as mentioned, the UP Law Center had the opportunity to host an academic symposium conducted in May 2024 entitled Political Dynasties, Biyaya o Parusa. And in this symposium, we were able to gather the inputs of former commissioner to the 1986 Constitutional Commission, Rene V. Sarmiento, the UP College of Law Dean and Associate Dean Gwen Grecia de Vera and Paulo Tamase, former Dean of the Ateneo School of Government, now Department of Education Undersecretary Ronald U. Mendoza, other members of the academe from the colleges of Public Administration and Governance and the Social Sciences and Philosophy, and as well as inputs from petitioners of a pending mandamus petition before the Supreme Court, attorneys Wilfredo Trinidad and Rico Domingo. And just to summarize some of these inputs that were also presented by Professor Garcia during the forum a week or 2 weeks ago. So, thin and fat dynasties are entrenched in the Philippines. The prevalence of political dynasties has been linked to high levels of poverty, underdevelopment, corruption, and poor governance. Political dynasties affect competition and economic growth, concentrating power to families which dominate business ownership in the provinces. The general avoidance of the three branches of government on the topic of political dynasty have deprived the Filipino people of the benefit of judicious stewardship of power to prevent undue concentration and potential for abuse. The issue of political dynasties must be addressed together with other democratic and political reforms and together with socio-economic empowerment. And though the Philippines is one of the few countries that has a constitutional provision banning political dynasties, the depth of the entrenchment of dynasties in the Philippines is of a different level. Hence, there is no exact similarity between the Philippines and other countries as to the issue of political dynasties. And finally, just to emphasize a point made by Commissioner Sarmiento during the symposium, there should be a prohibition against political dynasties over and above the right to hold public office. So we hope these insights would be useful as the committee proceeds with its deliberations on the proposed anti-dynasty bills. Thank you very much.
Thank you, Attorney. Again, do you have a presentation that you would like to submit to us?
Mr. Chair, we can just send the same presentation that Professor
Same presentation
Garcia.
kayo?
Yes, sir.
Okay, sige. Pakisubmit na lang po, ma'am, Attorney. Yes, thank you very much. Now, to speak on behalf of the Integrated Bar of the Philippines, the President of IBP, Attorney Alan Papanolong.
Mr. Chair, honorable members of the House of Representatives, fellow resource speakers, Assalamu alaikum warahmatullahi ta'ala wa barakatuh. Mr. Speaker, we reserve to submit our position paper with respect to the 4 questions that were enunciated before the resource speakers were allowed to speak, because there are interplaying principles that we have to consider in the position paper that we will submit before this August body. Nevertheless, Mr. Speaker, we have a position statement with respect to the 20 bills that are now pending before this House. May I proceed, Mr. Speaker? Bismillahirrahmanirrahim. Assalamu alaikum warahmatullahi ta'ala wa barakatuh. May the peace and blessings of Almighty Allah be with everyone. The Integrated Bar of the Philippines, as the compulsory national organization of Philippine lawyers and an institution committed to constitutionalism, accountability, and the integrity of democratic processes, supports the immediate enactment of the proposed anti-political dynasty measures pending in the House of Representatives. At the heart of these bills is a long-delayed constitutional command, Article 2, Section 26 of the 1987 Constitution declares, the state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law. This is a direct policy instruction to the political branches. For decades, the absence of an enabling law has allowed the continuing concentration of elective power, undermining electoral competition, weakening public accountability, and diminishing the constitutional promise of equal access to public office. Beyond Article 2, Section 26, the bills are reinforced by the following. Article 2, Section 1, the principle of republicanism and popular sovereignty. Public office is a public trust. Elective power must remain genuinely accessible to the people, not effectively reserved to a few bloodlines through entrenched name recall machinery and patronage. Article 3, Section 1 on the equal protection. Dynastic dominance produces structural inequality and political opportunity. A law designed to dismantle systemic barriers and open public service to broader participation advances, not violates, constitutional equality. At the Article 9 on accountability of public officers. Political dynasties heighten risks of capture of local institutions, including procurement systems, regulatory bodies, and even enforcement arms, impairing accountability mechanisms meant to check abuse of power. Fourth, the state's long-recognized policy against nepotism and public service, reflected in Administrative Code of 1987 or EO number 292 under Book 5, and in ethical standards under RA number 6713 or Code of Conduct and Ethical Standards for Public Officials and Employees. While elective posts are distinct from appointed positions, these laws embody the same public policy. Government should not be operated as a family enterprise. So the question is, why defining and prohibiting dynasties is necessary? The IBP emphasizes that the issue is not family relations as such. It is the consolidation of public power into private networks. A political dynasty in practice is sustained not merely by popularity, but the accumulation of durable advantages. Control of local party structures, patronage channels, access to state resources, and the capacity to deter challengers. The result is a cycle where elections remain formally regular, but substantively unequal, contrary to the constitutional guarantee of equal access to opportunities for public service. When multiple elective offices are held simultaneously or in coordinated succession by close relatives, governance can become insulated from scrutiny. Institutional checks become difficult where influence extends across local governments, legislative offices, and allied positions. The proposed prohibition and relatives holding two or more elective posts, or more than two, directly addresses the most common pattern of dynastic entrenchment. The IBP anticipates the argument that an anti-dynasty rule creates an additional qualification for elective posts. This is misplaced. The Constitution itself expressly contemplates a statutory disqualification to give life to Article 2, Section 26. This is not an ordinary legislative add-on. It is a constitutionally directed safeguard meant to protect the democratic system. Regulation of elections to promote fairness, prevent monopolies of power, and preserve meaningful participation falls within the state's authority, consistent with the constitutional design and the Commission on Elections' mandate to ensure credible elections. So we have recommendation for a strong enforceable law. To ensure clarity and withstand constitutional challenges, the IBP urges that the final measure should consider the following. Number one, define covert relationships with precision, degree of consanguinity, affinity, and specify whether the prohibition covers simultaneous holding or immediate succession. Include anti-circumvention rules. For example, resignation time to install a relative or use of dummy candidates. provide clear enforcement mechanisms through the Commission on Elections, including a fair hearing process, and treat violations as election offenses with proportionate penalties. Include a reasonable transition period without diluting the core constitutional objective. As a final note, the IBP calls on the House of Representatives or the Congress in general to enact the anti-political dynasty as a matter of constitutional duty and democratic necessity. Article 2, Section 26 is a promise of equal political opportunity. A republic that tolerates hereditary monopolies of elective power cannot credibly claim to guarantee equal access to public service. The time to define and prohibit political dynasties through a clear, enforceable, and constitutionally faithful law is now. Maraming salamat po.
Thank you very much, Attorney Alan Panolong. We will request you submit to us your position paper po. Maraming salamat, sir. Thank you very much.
Thank you, Mr.
So before we proceed, before we call on the next presenter, I'd like to acknowledge representative from the party list 4K, one of the authors actually, Representative Iris Marie de Mesa Montes. Thank you. Na-approve na po namin yun. Thank you. Thank you. Now we would like to recognize from the De La Salle University, Dr. Tihanki, Julio C. Tihanki, Professor of the Political Science at De La Salle University. Sir, you have a presentation po, no? Thank you, sir. Proceed po.
Thank you very much, Mr. Chair. First of all, I would like to thank the honorable members of the committee and August Chamber for inviting me to this very important and historic hearing. Just like Congressman Erice, I've been pushing for political and electoral reforms for close to 4 decades already, and I just turned 60 last month, so that's practically my entire life. And I've been studying the topic of political dynasties for the past 25 years. It was the topic of my doctoral dissertation. So I think I'm very hopeful, given the situation, that hopefully we can pass a workable and acceptable law after close to 4 decades of waiting. So I'd like to preface my presentation for this afternoon as the challenge of really defining and operationalizing Article 2, Section 26 of our 1987 Constitution. Okay, next slide, please. My clicker is not working, sorry. Okay. Yeah, so as have already been emphasized by the previous speakers, the mandate is there. It has been in the 1987 Constitution. The core issue and the task that's in front of us is really on trying to define the tipping point where kinship networks inhibit the constitutional guarantee of equal access to opportunities for public service. So I would like to pivot our discussion from an entirely purely legal perspective to a more academic one, although I'm a Tihanki, I'm not a lawyer, I'm more of an academic. No? I'm a political scientist. And I would like to present the perspective of social science and political science as regards the topic. Our approach in trying to analyze the contents of 20, imagine that 20 and more to come, bills in the House and 5 in the Senate, is really to look at essentially 4 what I prefer to call regulatory levers. These are the elements by which we can begin examining each and every proposed bill. And then, as we have heard from COMELEC Chair George Garcia, trying to come up with a workable anti-political dynasty law is really like a legal Gordian knot.
So it will take a lot of brain power, not simply from a legal perspective, but from everybody to really come out with a practicable and implementable law. So our objective really is to provide a technical comparison of both. Next slide, please. Okay, so as already mentioned by the previous speakers, it's 38 years of legislative inaction. The closest we have reached was the plenary in 2013, and then in 2016, if I remember correctly, the second to the last State of the Nation address of President Noynoy Aquino, he promised to push for the anti-political dynasty, but again, it died in the upper chamber in the Senate, given the election of 2016. And in the previous administration of Rodrigo Duterte, there was an attempt to push for comprehensive political and electoral reform under the so-called Puno Commission of the Consultative Committee to review the 1987 Constitution, of which I was a member of as chair of the subcommittee on political and electoral reform. And I remember working with some of you here in trying to craft the anti-political dynasty provision. And then, next slide, please. So, okay. So, of course, we have heard a lot about the term fat and thin dynasty. No? This is the acceptable terminology now used in the literature of political science, particularly in Philippine political science. No? And it simply refers to two aspects of dynasties. No? The first being the traditional notion of political dynasty. It was mentioned earlier that dynasties have existed since the birth of this republic. It's true. But originally, the type of dynasties that we had back then was the so-called thin dynasty, where families, pass on at least the machinery to get elected to the next generation. So this is the successive, no, or yung tinatawag po nating sunod-sunod, no. And what we are seeing right now after the 1986 EDSA People Power Revolution, with the restoration of liberal democracy, electoral democracy in the country, is the simultaneous fat dynasty, no? Yung sabay-sabay po, no? At ngayon po, hindi lang siya fat, tinatawag na po siyang obese, no? And again, this was the topic of my doctoral dissertation in 2000, no? And tama po si Congressman Miro Kimbo na ang isa po sa mga dahilan kung bakit dumoble, trumiple ang mga fat dynasty ay dahil po sa term limit, dahil napabilis po ang pagpasa ng kapangyarihan sa mga kamag-anak. But then again, no, the reason why it happened was because hindi nga po naipasa yung anti-political dynasty. Kasi kung babalikan po natin yung transcript ng Constitutional Commission, makikita po natin sa diskusyon at debate nila na ito po ay dapat magkasabay. So dapat yung term limit sinabayan ng anti-political dynasty provision para hindi magkaroon ng leakage, so to speak, ng loophole. Kaso po, nagkaroon po ng term limits, kaso hindi pinatupad ang anti-political dynasty. Ang unintended consequence po nito, dumoble, trumiple, at lalong nagkaroon ng incumbency advantage. Now, how do we try to address this problem? So, next slide please. I would like to propose a simple framework upon which we can begin dissecting the issue, and then we can jump off to the other more complicated aspects later on. The first one is the question of relationship. No? Palagi pong nami-mention yung consanguinity versus affinity, kung second or fourth. The other one is the timing. Kailan po ba ito mag-a-apply? Yung sabay-sabay o sunod-sunod? Then, yung third po, anong posisyon ba ang kasama dito? Yung national, local, o pareho? Tapos pag inisip po natin yung posisyon, ano po ba ang jurisdiction? Ito ba'y territorial, sa isang probinsya lamang, sa isang distrito lamang, or ito ba'y hierarchical or vertical? No? So halimbawa, ang senador, may kamag-anak na mayor, pwede po ba yun? No? So ito po yung apat na pwede nating simulang i-discuss para tayo makausad sa usaping ito. No? The first one, next slide please, is how do we define? No? Now, if we review all the proposals and the previous proposals in previous Congresses, democracy or oligarchical democracy. No? So, isa po yan sa unfinished business ng 1987 Constitution, no? Kung saan hindi po na-consolidate, na-deepen yung gains ng people power revolution. So, regulating in terms of ito ba ay simultaneous? No? Next slide please. Simultaneous or via succession, no? Or sabi nung iba, no? Kasi nga the political reality is we cannot pass this bill without the active participation of the members of the dynasties themselves, right? So give and take po ito, no? And sabi nga nila, politics is also the art of the possible. The mere fact that we are already seriously discussing this at this point in time, and there are many, no, members of political dynasties who are open to passing this, is already a big achievement. And so the other option would be just like in the term limits, there is a cooling off period, no? So pwedeng gawin din yon. Now, in terms of the next slide, please, yung geography and hierarchy, the reach of the ban, no? Is it horizontal, no? Katulad po dun sa illustration natin, no? Yung overlapping constituencies o yung tinatawag na cross territorial jurisdiction, no? Kailangan din pag-isipan kung paano 'yan. Tapos next slide please, yung scope, no? Is it territorial or national, no? Or yung sinasabi po ni Congressman Erice na maximum of 2. Isa din po ito sa na-discuss nung Puno Commission na since why give the burden to COMELEC or the public, leave it to the dynasts themselves, no? Kung sino sa kanila, just limit it to 2, no? So in this regard, the Erice proposal speaks more to the regulation rather than the total ban. And at this point in time, given that a majority of our active public servants, elected public servants, are members of dynasties or are building their own dynasties, it is difficult to have an absolute ban. No? Yun po ang realidad. Mahirap po magkaroon ng absolute ban. So what can be expected right now would be more of regulation, no? Bakit po regulation, no? Kasi po later on ulitin ko po itong puntong to. 'Di ba po sa free market economy, no? Pag merong oligopoly o monopoly, konti lang ang nagko-control sa merkado at sa negosyo, meron tayong market failure. Pero kaya natin kailangan ng antitrust law and regulate kasi po pag may monopoly, oligopoly, ang dehado po dyan ang consumers. Ganun din po sa eleksyon, sa politika. Pag meron kang dynasties, ito po ay isang form ng political monopoly or political oligopoly. And there is justification to pass an antitrust equivalent in the electoral sphere. So, next slide, please. Some of the cases are looking at the barangay, but we have to, again, look at the impact on the SK law, because the SK law is an experiment in democracy because it is the first law that has an anti-dynasty provision. And of course, also the Bangsamoro Electoral Code. And then the other issue, which will deserve a separate hearing, I guess, and a separate law, is the party list backdoor. No? Of course, there are already several proposed bills to reform and amend the party list law. Now, our spectrum of choice would be, next slide please, would be, and this is for the committee and the technical working group to decide whether are we going to be satisfied with the permissive version or a minimal ban, second degree only, simultaneous only, and local positions only, or is it really realistic to have the absolute, strict, fourth degree, including cousin, simultaneous and succession, and nationwide? Or shall we start with our respective position, like some members of the House might allow for the minimal ban, the permissive, but the civil society organization, like a new multi-sectoral organization, the Anti-Dynasty Network, was launched last September. This is a group of academics, professional, civil society organization, and members of progressive dynasts, no? Members of political dynasty, like Mayor Vico Soto, who is spearheading this multi-sectoral campaign to push for the passage of the anti-dynasty. So the position of civil society is the maximum. But many members of civil society and academia are open to negotiating. Magtagpo po tayo sa gitna. Naiintindihan din po namin that there are political incentives and disincentives for pushing for this law. So, next slide. So, for example, just a sampling of out of the 20 plus bills, no, we can already see the differences, no, and there is a more comprehensive table that has been circulated to the committee, so I will no longer discuss that. Next slide, please. Also in the Senate, no, supposedly tomorrow there will be a Senate hearing, but they canceled it because of the change in the chair of their own Senate Committee on Suffrage. Now, it has been asked, meron na bang ganitong klaseng batas sa ibang bansa? Next slide, please. Oo, meron na po, no? Lalong-lalo na sa Latin America. And Latin America and the Philippines are very much similar, no? Parehong-pareho po tayo sa Latin America. Meron na pong similar legislation sa anti-dynasty sa 1949 Constitution nila, and then also in Honduras, Paraguay, Colombia, which had the similar political trajectory like the Philippines, in the sense that we have been through democracy, dictatorship, redemocratization, and consolidation. So we've had the same political, historical trajectory with these countries, and they've implemented their own anti-political dynasty law. So next slide, please. I'm down to my last 3-4 slides. No? So next slide, please. There. No? So as was mentioned, SK and Bangsamoro Electoral Code, and also the Civil Service Rules on nepotism. Next slide, please. Okay. Yan. Ngayon, ito po ang pinaka-importanting gusto po naming i-share sa committee, no? There have been several studies that have said, no, this is the Philippine Institute of Development Studies, Ateneo School of Government, LaSalle Institute of Governance. Balik po tayo dun sa previous slide, ayan. Maraming pag-aaral na po ang nagsasabi na may correlation yung poorest provinces doon sa mga lugar na may highest concentration of fat dynasties, no? So, may empirical data po at may empirical evidence na po na nagtuturo niyan, no? Ngayon, may causality, no? Why? Because dynasties limit political competition, yung tinatawag nga nating monopoly, at bumababa yung accountability at walang good governance, nagkakaroon ng poorer public service. At ito pong mga recent na pangyayari sa flood control scandal ay nagtuturo po dito sa sitwasyon natin. The erosion of checks and balances, no, pag yung conflict of interest exists. And then next slide please. According to the Pulse Asia survey, latest survey, 54% majority of the Filipinos are now supportive of a ban on political dynasty. Ito ba ay labag sa prinsipyo ng equal opportunity? Hindi, no? Because the reason why we have Article 2, Section 26 is it's working on the premise that democracy is also about giving chance to others, especially those who do not have the incumbency advantage of name, machine, and wealth, no? So, the point of this entire exercise is really to promote meritocracy. Elections based on platform and performance, not name recall. And actually, it's not against sovereignty of the people, but really to restore the power of the people to freely choose their elected representatives. So, next slide, please. I'm down to my last three, no? So, again, yung palaging sinasabi, let the people decide, no? Wala pong dynasty dahil na-elect naman sila. Meron po tayong konsepto sa political science na tinatawag na incumbency advantage. At yung prinsipyo po ng power begets power. Once you get elected, you get the incumbency advantage. And once you stay longer in power, the more incentive for you to stay longer and to pass it on to your next of kin, no? So, at pag nagkaroon na ng ganong sitwasyon, it will become a vicious cycle in which limited competition will result in poverty that will work to the advantage of those in power. So it punishes competent families, no? It is not about competent. May mga magagaling pong miyembro ng political families. Totoo po yan. Pero hindi po yun ang problema. Ang problema po, 80% na po lahat miyembro ng pamilya. So, hindi na po demokrasya yun. No? So, it's not a question of competence. But in fact, the more competent members of political dynasties are now open and actively pushing for this one. Right? So, that is already a good indicator. And then, does it target specific people? Hindi po. No? It is a systemic structural issue that needs to be addressed. So, last two slide, next slide please. So yung question kanina, whether it's, how do you balance the right to run and the public interest of equal access? Well, the Constitution has already mentioned that in Section 26. And the Supreme Court in Quinto versus Comelec, the state has police power to regulate candidacy. And as was mentioned earlier, the right to be a candidate is not an absolute right, just like most other rights in our Bill of Rights, no? So the reality is that fat dynasties monopolize resources, making a fair fight impossible, okay? So moving forward, and this is my last slide, and I hope to work closely with the committee and with the chair, who's a friend of mine on Facebook. We have to select. This is the path forward, no? Defining the law. You select first whether we are for the maximum, fourth degree, or are we going to compromise on the minimum basic, which is second degree? Then is it simultaneous or both succession and simultaneous? And then we harmonize everything. And hopefully, again, as I've mentioned, this is a very historic and critical period in our nation's democratic history in which the people are anxiously waiting for the House and the Senate and the Congress to really pass this law and to restore trust in our political institution and trust to our democracy and give hope to the more talented future generation of young leaders who are willing to help and sacrifice and contribute to nation building but cannot because of dynastic monopoly. Maraming salamat po sa inyong lahat.
Maraming salamat po, Professor Tihanki. I'm an avid liker of all your Facebook posts.
Thank
you. Kung mapapansin niyo po. We will be, thank you very much for your presentation. This will help us a lot in, trying to navigate the complexity of the subject matter. Maraming salamat po. Before we proceed to the next presenter, I'd like to recognize Congresswoman Agustina Dominic Ditsitina Pancho of the 2nd District of Bulacan. Later on, may mga, I'd like to request all guests to please remain po kasi there will be several questions that will be asked by our members of the committee. So, stay put lang po tayo. Malapit na po tayo matapos. Also, Deputy Speaker, JJ Kunghun, thank you, sir, for joining us here today. So we proceed to the next guest, Dr. David B. Yap. He's the author of the book entitled Political Dynasties in Poverty. He is now working with the House of Representatives, Director of the Congressional Policy and Budget Research Department. Dr. Yap, please. Kailangan kong sabihin yun para mag-shorten yung mo.
That's not me. Good afternoon po, Mr. Chair, esteemed members of this committee. Before I begin, I'd like to emphasize that these views are my own and not the official position of the CPBRD. So I preface my prepared statement with a specific definition of a political dynasty. A political dynasty is a family that has at least 2 of its members occupying at least 1 elected position over at least 2 consecutive terms. The longitudinal component deserves emphasis as it is integral to the definition of a dynasty. The implied succession is what signals the transmission of political capital from one family member to another. This can then be argued to be the basis of the argument that dynasties diminish competition within a democracy. Scions of political dynasties are, in essence, bequeathed advantages in elections by their forebears and crowd out non-dynastic candidates. In taking over a position held by a family member, he or she takes advantage of the goodwill, familiarity, brand recognition, and trust associated with his predecessor. While the latitudinal component or the expansion of the political dynasty is indeed a remarkable feature of many dynasties, it is neither a necessary nor sufficient condition for a family to be considered as a dynasty. A family, after all, cannot be considered as dynastic if they fail to secure their positions after a single political election cycle. The proposed definition, in turn, has significant ramifications on any proposed regulation of political dynasties. If there would indeed be anti-dynastic legislation, then it needs to impose restrictions not just on the commonly invoked latitudinal aspect of political dynasties, but also its longitudinal aspect. Another point of interest that seems tangential, but is in actuality germane to the present discussion, is that the initial emergence of political dynasties was, at least in part, attributable to the imposition of term limits on elected officials by the 1987 Constitution. From a purely practical perspective, politicians merely adapted to the change in the political environment. They needed to field relatives in order to maintain their hard-fought store of political capital and ensure their long-term political survival. This in turn reminds us that incentives matter, or more specifically, people respond to incentives. People adapt to changes in incentive structures. Policymakers are thus enjoined to consider the likely adaptations to anti-dynastic legislation and perhaps amendments to existing laws on term limits should they pursue electoral reforms along the lines of political dynasties. With that said, let us proceed with a simple example. Suppose both houses of Congress are committed to passing anti-dynastic legislation. Let us further specify it as a ban on political dynasties. The primordial question, as we have seen from the previous discussions, is definitional in nature. What is the operational definition of a political dynasty? While the aforementioned definition describes a political dynasty in principle, it is inadequate for the purposes of enacting legislation. Specifically, up to what degree of consanguinity or affinity is covered by the ban. If the ban on political dynasties extends up to the first degree, then existing and prospective dynasties can simply field siblings, grandparents, and grandchildren in their stead. Similarly, if the ban extends only to the second degree, political clans can have aunts, uncles, nieces, and nephews run for office. At this point, we may be tempted to simply oppose a ban up until the fourth degree, an exceptionally strict constraint. Surely this prevents the emergence of political dynasties. While it does eliminate a lot of the situations that we see now, this heavy-handed approach can still be circumvented by especially astute and dedicated political clans. Power, for example, can be rotated across at least two families unrelated by blood or affinity, but allied purely for political purposes. In this scenario, a political family survives by leapfrogging between political election cycles. A more fundamental problem with a blanket ban is that it prevents multiple families from fully participating in the democratic process. It may be the case that a promising, honest, and wholly capable individual is prevented by the incumbency of his cousin. Napkin math would suggest that a ban extending to the fourth degree, assuming that the number of children per family is around 3 to 4, would disenfranchise upwards of 13 to 21 nuclear families with the election of one individual. This number doubles upon marriage. Granted, there are millions of Filipino families who can field candidates, but are we to assume that all members of all Filipino families have the inclination and the wherewithal to assume public elected office? For starters, there are people who are wholly disinterested in politics and governance. Moreover, the recent scandals involving flood control funds have demonstrated that there are families who are keen to get into office, but only for the pecuniary benefits it implies. Even if we are to assume that there are enough politically inclined and civic-minded families among the population, this type of legislation would unambiguously infringe upon the right to choose of voters. It reduces their options. What if a person truly wants to vote for a scion of a political dynasty? Preventing him or her from voting for a candidate from a political family curtails his or her democratic rights. Even if we do concede that political dynasties diminish political competition by preventing others from fully participating in the democratic process, it does not invalidate the proposition that reducing the options of voters through anti-dynastic regulation reduces democratic freedoms. Ultimately, heavy-handed anti-dynastic legislation has non-negligible and adverse effects on fundamental democratic rights. Anti-dynastic legislation may also result in unintended and unwanted second-order consequences. Within the framework put forward by Mancor Olson, it may be the case that we trade a stationary bandit, an extractive agent that nevertheless wants to ensure that he receives a steady flow of rents over the long term, for a roving bandit, an extractive agent who plunders as much as he can before his term expires. But differently, the political dynasty is motivated by the desire to perpetuate itself in power. It would, in many situations, maintain a certain level of restraint in order to establish, admittedly, a low-level equilibrium with its constituents. There would be some appreciable level of good governance in these situations. An unscrupulous individual, on the other hand, recognizing that he has but one term, may be wholly disinterested in governance and instead devote his energies towards raiding the public coffers. On the topic of the relationship between political dynasties and poverty, it is important to disabuse ourselves of the reductive proposition that political dynasties cause poverty. Poverty is the default state. It needs no proximate cause. It is true that some political dynasties may prevent a jurisdiction from proceeding from poverty to prosperity. By monopolizing political power, they dismantle systems of checks and balances and redirect resources for public use towards personal ends. It is, however, also not true that all political dynasties aggravate poverty. Some political dynasties may be invested in their respective legacies and are truly intent on instituting and preserving beneficial reforms across generations. Our work on dynasties over a decade ago found that the effect of political dynasties on poverty was hugely dependent on the location of the province. In particular, political dynasties exacerbate poverty in provinces outside of Luzon. As the statistician in charge of modeling, I can tell you definitively that the statistically significant relationship was hugely dependent on the relatively high levels of poverty and dynastic prevalence in Mindanao during that time period. But differently, the stability and validity of the model was wholly contingent on the interaction variable for the location. It is also instructive to consider the converse. Poverty may create political dynasties. Privation, for example, can make voters markedly more susceptible to patronage politics. Assistance during desperate times compels some measure of reciprocity. Low-income households could thus become beholden to political patrons throughout the political cycle. Cash and favors before elections, during special events, and after crises could prove sufficient to secure the loyalty of the impoverished. Poverty could also make it difficult for people to consider longer-term concerns and instead become intensely focused on immediate concerns. The preceding discussion surfaces yet another and potentially uncomfortable point. The unavoidable truth of the matter is that the Philippine electorate was, in fact, responsible for the proliferation of political dynasties. Whether for good or ill, it is the generations of voters who chose scions of political dynasties. We may not agree with their choices, but if we are committed to the principles of democracy, we are obliged to respect their choices. The imposition of anti-dynastic legislation can, in a way, be viewed as a tacit admission that there are right and wrong electoral choices, and more importantly, that many Filipino voters cannot be trusted to make the right choice. More to the point, in recognizing that the emergence of political dynasties was the result of the choices of our voters, then it stands to reason that it is well within their power to dismantle political dynasties even without legislation. An alternative solution to the problem at hand may not be the reduction of freedoms, but the expansion of freedoms, particularly to access to quality information regarding candidates and the responsibilities of the positions they hope to hold. Finally, I would just like to pose this particular question. I think it boils down, one important question that hasn't been surfaced thus far is that, do we trust Filipino voters to be sufficiently discerning and responsible? In my view, if the answer is yes, then we do not need anti-dynastic legislation. If the answer is no, then we have a fundamental problem with our democracy because we do not trust our voters to be sufficiently discerning or responsible. So, thank you.
Thank you very much, Dr. Yap, for that. Do you have a presentation that you'd like to submit to us? Or it's just your position paper?
The position, I have submitted po in advance the
Okay,
paper that we wrote several years ago, as well as the position paper of CPBRD that we put forward several months ago po.
Yeah, because you raised good points eh. So
Thank you, sir.
I was wondering if you had that translated into a presentation.
I can send this, sir. If, if,
you did?
Mr.
You
Chair.
did? Did you have that?
I can submit a copy of this,
sige
sir.
na lang. Sige. Okay, thank you.
Thank you, sir.
Thank you, Dr. Yap. So now we move on to our former colleague. Sabi nga nila, once a congressman, always a congressman. Without, of course, the privilege of vote. So, yes, Attorney Nery Colmenares, Chairperson of the Bayan Muna Party.
Thank you, Mr. Chair. Maraming salamat. Good afternoon po sa lahat ng nandirito ngayon. The reasons, may slide pala ako. Can you please show it kay Kim? Yes. Yes. The reason why it is imperative for Congress to pass an anti-dynasty law is very clear in the explanatory notes of all the bills. In fact, next slide, please. If we look at the bills, these bills say that dynasties perpetuate inequality and undermine strong democratic institutions. House Bill 2037. HB 6894 declares that political dynasties undermine democratic ideals of equality, undermines the development of strong democratic institutions. HB 6886. Dynasties reduce political competition. HB 2037. The fundamental aspiration of fairness, equality, and genuine public service is hindered by the absence of an anti-dynasty law, HB 6671, which I think is authored by the Speaker. Not only in electoral contest, but in the access to economic and political resources, contravening the social justice principles of our Constitution, House Bill 209, House Bill 2037, and 5905. House Bill 6799, in fact, said that the reason for these structural inequalities is the concentration, consolidation, and perpetuation of political powers in the hands of a few families and clans. So, klaro po sa mga bills na yan, I will no longer delve on it. It endangers a patronage system, HB 209, 2037, etc., Mr. Chair. Next slide, please. Next slide. I will no longer dwell on that. So, not this research, these positions of members of the House who authored the bills were actually confirmed by researchers abroad and even here in the Philippines, that where areas where dynasties are pervasive, these areas are racked with poverty, ineffective governance, inequality, violence, and corruption. And there are many, in fact, I think some of our resource persons have already said this. So, if everybody agrees on the pernicious effects of dynasties in Congress and out of Congress, why has this not passed? Then this is the best law that never passed Congress, because everybody seems to agree that it must be prohibited. Next slide, please. The question is, does the Constitution demand the passage of an anti-dynasty law? In my opinion, Mr. Chair, yes. The Constitution not only commands that the state prohibit political dynasties, but actually commands Congress to pass the law. That is clear, in my opinion, Mr. Chair, with the phraseology of Article 2, Section 26, and even the debates in the Constitutional Commission. So, the prohibition is not a matter of policy, Mr. Chair. The prohibition under Article 2, Section 26 is a command on Congress to pass the law, however you define it. Otherwise, as the Supreme Court said in the case of Manila Prince versus GSIS, the legislature would have the power to ignore and practically nullify the mandate of the fundamental law. And the Supreme Court added in Manila Prince that government cannot shirk from its constitutional duty that arises out of the failure to pass an enabling law. So, following this constitutional command, Mr. Chair, and due to the public clamor at the time, and in fact there were ideas of a people's initiative to pass a law that prohibits political dynasty, the House of Representatives actually followed that constitutional command and passed an anti-dynasty law, at least in the committee level. And maybe Congressman Rufus was there too. Next slide, please. And that is House Bill 3587. In 2013, for the first time in history, the House Committee on Suffrage and Electoral Reform tackled and approved House Bill 3587, an act prohibiting the establishment of political dynasties, which prohibits two or more persons within the second degree of consanguinity or affinity from running or holding elective positions in local and national elections. Yun ang pinasa ng Committee on Suffrage. And I remember that day when then Chairperson Freddy Neil Castro, who banged the gavel and said, "This bill is approved." The media ganged up on him immediately, and he was really bewildered, Mr. Chair. And after that, he asked me, "Neri," because I was the author, "Neri, what is all this fuss about?" And I said to Chairman Fred Castro, "Fred, you just made history." Kasi first time yun na nangyari, Mr. Chair. Balik lang sa slides, please. the House of Representatives made an historic move to conduct deliberations on House Bill 3587 on second reading from May to December 2014 until the period of committee amendments, Mr. Chair, umabot dun on May 13, 2015, where the House deliberated on the bill. Unfortunately, my term here is I know of no report of a similar approval in the Senate. So talagang it was a Mona Lisa situation. Hindi siya talaga papasa. Next slide, please. Now, many of the provisions of HB 357 are contained in or similar to provisions of the pending bills now. In 3587, a political dynasty exists when two or more individuals who are related within the second degree of consanguinity or affinity hold or run for national or local in successive or simultaneous or overlapping terms. That was the provision. With regards the relationship and the prohibited acts, no person within the second degree of consanguinity or affinity, whether legitimate or legitimate, full or half-blood, to an incumbent official seeking re-election or another candidate seeking re-election shall be allowed to hold or run for local or national elections in the same election. So the bill that passed the committee did not make any differentiation as to what jurisdiction the dynasty law applies. Next slide, please. But what was the most debated provision, Mr. Chair, during the time? The most debated provision at the time was whether to allow only one or two dynastic relations to hold public office. That was the level of discussions. Section 3 of House Bill 3587 says a political dynasty exists when two or more individuals who are related within the second degree of consanguinity or affinity hold or run for national or local. Walang distinction. The alternative provision being proposed at that time, Mr. Chair, was a political dynasty exists when more than two individuals who are related within the same prohibited degree. Meaning the alternative proposal then was to allow two. That was where the debate was. So, in the end, as I mentioned, it did not pass the House. Next slide, please. But this is my reading of the, I wasn't able to read all, but the degree of consanguinity or affinity. Congress can act if it is a command of the Constitution that Congress passes a law. It's a mere selection on the part of Congress whether select second degree as proposed by nearly 11 bills or fourth degree relations as proposed by House Bill 209, 4784, 5905. And in my opinion, Mr. Chair, it should not be a deal breaker. That's the first. Prohibition in any election. For me, Mr. Chair, this is the gist of this discussion. For me, in my opinion, if Congress really intends to pass a genuine anti-dynasty law, it can select from the bills which applies the prohibited relations in all public office, whether national or local, which is proposed by 209, 4784, 2037, House Bill 5905, 6886, 6799, and 6826. So for me, if we distinguish, which was not an issue in 3587, between national or local and various provinces, then there will be instances when 5 or 10 or 15 or more public officials have dynastic relations, which not only will defeat the constitutional intent, Mr. Chair, but could even get the ire of the public. Baka sabihin ng publiko, nagpasa pa kayo ng anti-dynasty bill, 5, 10 rin pala yan in the end. So doon ang careful. Next slide, Mr. Chair. So para sa akin, ang major issue dito, Mr. Chair, is for the Congress to decide muna talaga. Ilan ba ang papayagan natin? Anong numbers ang i-allow natin? 1, 2, yun yung ang parameters. The moment Congress has decided on how many to allow, the rest of the provision will fall into place. Nitty-gritty yun, yung mga pinoint out ni Chairman Garcia, pwedeng pag-usapan, disqualification, cancellation, etc. Yun ang pinaka-crux. So the most important is, may decision muna ilan ba talagang papayagan. Ano ba ang number na acceptable sa Kongreso at sa publiko? Last slide, Mr. Chair. Last slide. I would just like to read, meron bang slide dyan after that? Sa thank you. After sa thank you. I would just like to read the speech of Speaker Feliciano Belmonte calling on the House to pass the anti-dynasty bill at the opening session of the second regular session of the 16th Congress. Sabi niya, it has been 27 years since the 1987 Constitution was ratified and took effect. To this day, various provisions have yet to be fully operative due to the absence of relevant implementing law. Section 26, Article 2 of the 1987 Constitution categorically prohibits political dynasties. But no law has been passed to implement this constitutional mandate. For the first time ever in 27 years, we have House Bill 3587 or the Act prohibiting the establishment of political dynasty. It is the first ever to pass committee deliberation and is now up for preliminary discussions. We must proceed in earnest to examine the merits of this bill and lay out the parameters for its application towards creating effective deterrence to the establishment and perpetuation of political dynasties in all levels of government. Speaker Belmonte, that bill will have implications on the political fortunes of Speaker Belmonte. In the same manner, that bill will have an impact on the political fortunes of Congressman Fredinil Castro. But they passed and approved and supported it, and there will be sacrifice, Mr. Chair. There will be sacrifices from among our leaders, but I really hope that the constitutional command for Congress to pass a law must be fulfilled and satisfied, Mr. Chair. So it's about time, Mr. Chair, that the House of Representatives and the Senate, both houses of Congress, to pass an anti-dynasty law and take out what many of the authors, all of the authors of the bill, believe as a pernicious and destructive impact on our society, the political dynasties in our country. Thank you, Mr. Chair.
Thank you po, Congressman Colmenares, and thank you for, to walk us through memory lane. But what we can assure you at this point in time, I think at least on this Congress, is we will pass this anti-political dynasty. Thank you very much for that very wonderful presentation. Na-remind tuloy si Boss Roman at saka si Kong Rufus. Thank you. So we now move to our next presenter, a guest from the UP National College of Public Administration and Governance, Professor Michelle Castillo. Professor.
Thank you so much po. Isang mapagpala at mapagpalayang hapon po sa ating lahat. On behalf of Dr. Christopher Bercy at the UP National College of Public Administration and Governance, we'd like to thank you for giving us this opportunity na maging bahagi po ng napaka-importanting pag-uusap na ito sa polisiya ng anti-political dynasty. So I'll be sharing with you the insights from our position paper, which we've already shared with the committee. And so let me just read some of the key points as well. The struggle to prohibit political dynasties in the Philippines is a battle for the soul of our democracy and a stride towards better governance that can truly promote the welfare of every Filipino. After nearly 4 decades, which have been emphasized already several times, the state policy to guarantee equal access to opportunities for public service and opportunities and prohibit political dynasties as may be defined by law, it remains unfulfilled. The widely studied impacts of dynastic politics, including poor quality of governance, dismal socioeconomic outcomes, and worsening levels of poverty and inequality, underscore that this long overdue legislation is not merely a matter of legal compliance or constitutional compliance even, but an urgent and a moral imperative towards a just society, inclusive progress, and sustainable development that every Filipino deserves. The select members of the UP-NCPAG, together with the Governance Reform, Innovation, and the Transformation Collab, we are manifesting our strong support for the immediate enactment of an anti-political dynasty law. And again, I'll be sharing some of the key points from our position paper. The recent corruption issues involving dynastic officials have obviously turned the tide of public opinion regarding this issue. In place of public resignation, whereas before nagkaroon na lang po ng attitude na okay na to, tanggap na natin yung katotohanan ito, we now have a stronger expression of public indignation against dynasties. Not necessarily because of families, no, but because of the impacts. Meanwhile, the more sober and arguably objective evidence in various studies, which our colleagues from different academic institutions have already presented, they have been consistent in raising the alarms against the negative impact of the persistence of political dynasties in the country. Earlier, it was mentioned that dynasties are inherently neither good nor bad, but evidence on their impact shows that they are actually bad. We use evidence correlating dynastic prevalence to poor governance and dismal socioeconomic outcomes in saying so. And we say that good dynasties are exceptions rather than the rule. In the same way that, we have non-traditional politicians, we celebrate non-traditional politicians having wins over these dynastic officials or candidates. But again, they're also exceptions rather than the rule. And let me just share an experience from our college when we coached a mayor from Palawan, from this very small municipality. Hindi siya bahagi ng dynasty, no, pero nanalo siya. And then nung nanalo siya, hinaras siya nung mga nandun sa Sanggunian, nandun sa LGU, precisely because he doesn't know the ins and outs of politics. No? So, na-mention kanina the incumbency advantage, the power treatment effect. Those who already know the ins and outs you can actually really harass those who doesn't know the nitty-gritties of politics. So, anyway, the results of this entrenched system are clear. Persistent inequality, as mentioned, worsening poverty, and ineffective democracy. So much so that, scholars and experts would say that we actually don't have a democracy. We have an oligarchy. Dynastic dominance reinforces patronage politics, where government positions and projects become rewards for loyalists rather than merit-based services. And this elite capture of the political system stifles healthy competition and prevents the attainment of national goals, making the passage of the anti-dynasty law not only, again, a constitutional and political imperative, but a moral one. Indeed, the consistent failure of Congress to enact a law defining and prohibiting political dynasties as required by the 1987 Constitution, to us, it does not come as a surprise, given that, as already showed by the statistics, no majority of those in Congress, including party list representatives, sadly, are themselves part of political dynasties. As another round of proposed bills are being deliberated in the 20th Congress, it's an opportune time indeed for the legislature to strengthen public trust in this institution by performing your responsibility given to you by the 1987 Constitution. And so we have high hopes po that our honored representatives will rise beyond their familial ties and truly promote public interest above their own. At bilang siguro po ordinaryong mamamayang Pilipino, I would like to say thank you for having this conversation. We see that you've been saying na you're serious, and we are somehow in this conversation seeing that. And sana po magtuloy-tuloy, ano? And let me just share as well from an academic perspective, as a educator, it's a good case study in the process of policy making. And we are hoping that you will be remembered in history as an exemplar who broke this institution that is inimical to our democracy. It's going to be interesting because the very institution that is mandated to promote this policy is the one whose members will actually suffer most from it. A common argument against anti-dynasty laws is that they restrict the people's right to elect the candidate of their choice. And this was posted as a question earlier to the resource persons. However, this perspective ignores the massive barriers that dynasties create, which effectively deny many qualified citizens their right to run for public office and to have actually genuine choice of candidates. So while our legal framework provides for equal entry in theory, the reality is far different due to several systemic barriers. One of them is the high cost of elections. We see the extreme financial burden of running for office. It promotes an entrenchment of the patronage system. It prevents qualified candidates who lack substantial personal wealth or machinery for competing on a level playing field. And again, already mentioned the incumbency advantage or the power treatment effect of incumbency. This incumbency advantage means that long-term dynastic officials, they amass name recognition, financial resources, and political connections that they pass on to their successors. And it gives dynastic candidates an insurmountable electoral advantage over non-dynastic challengers. And finally, again, limited electoral choice. Rather than protecting the right to elect, the presence of dynasties often reduces the choice of the electorate to a pre-selected group of family members. The expensive election campaign that prevents the entry of more qualified candidates that lack the resources, it effectively limits the options, and this imposes limitations on the exercise of democratic choice of the voters. So our position is that, therefore, prohibiting political dynasty should not be viewed as a restriction to democratic rights, but as a measure actually to restore them. By lowering structural barriers to candidacy, the anti-dynasty law expands the right to run for public office and in turn enhances the right to suffrage. When elections are opened to a broader pool of qualified candidates, voters are empowered to make genuine choices. So in this room of policymakers, legal luminaries, legal experts, and practitioners, allow us to offer a public policy and governance perspective in looking at political dynasties. Addressing political dynasties is a wicked problem. So may I ask for the slide to be shown? It's a wicked problem, not only because of its impacts, its negative impacts, again, actually question even of justice, no? We're seeing the effect on the very lives of the Filipino people. Political dynasties is a wicked problem. It's not easily solved with a single solution, nor are the root causes and their effects easily mapped and structured. The problem should be framed as a systemic issue that requires more than just banning certain individuals or families from running for political offices. It requires reforming the institutions that allow political families to exist and persist. Interventions must also be carefully studied as they might create more problems instead of solving the current issue. And that's the nature po of wicked problem. No? Minsan may solusyon tayo tapos nagiging sanga-sanga kasi yung gumagawa siya ng additional na problema. So for instance, the introduction mentioned earlier already, term limits through the 1987 Constitution, it's been argued to have incentivized the creation actually of political dynasties. So one way of framing the problem is to consider the existence of the market for political families. No? They exist and persist because there's a market for political dynasties. There's a supply and a demand for them in the Philippine electoral system at various levels, from the institutional down to the individual level. Therefore, interventions must correspond to this market of political dynasties. The supply can be addressed also by curbing the demand and strengthening electoral competition because precisely political dynasties, meron tayong monopolyo, no? So one policy alternative, or oligopoly, one policy alternative that we are also offering as a consideration, but perhaps beyond the scope of the current bills right now, is the political party development. And actually in the previous Congresses, meron na pong mga bills na nailatag dito. So this is pushing for stronger electoral reform in terms of strengthening our political parties, so that it's not just the demand, supply demand for the political families that will be addressed, but also supply and demand for for candidates coming from those outside the political families. So overall, studies have generally shown that political dynasties have been inimical. So I'm showing here the different antecedents of political dynasties and the possible policy alternatives that can also be considered probably as part of the current bills, but also in other policies that the committee might consider. So as you can see there, political dynasties is just one policy alternative. There must also be other policies and programs to strengthen political competition and also strengthening or improving voter education. So in terms of the provisions of the current, rather the contents of the current bills, I'm going to share our positions. So overall studies have generally shown political dynasties, as I said, inimical to public interest. And given the pervasiveness of the problem, any proposal to regulate this dynastization must be expansive to cover not only second-degree relations, but also other relatives deemed influential in the extended nature of a familial relationship among Filipinos, including co-parents-in-law, mga magbalae, and brothers or sisters-in-law. And to soften the transition, we are proposing a phased-out approach, which may be adopted. So we have a study that shows that a graduated phase-out provision can be included, probably as a sunset clause, in the current anti-dynasty bills that would prohibit certain features of political dynasties at succeeding election intervals. So for example, banning fourth and degree relatives in the 2028 election, second degree in 2031, and then first degree in 2034. So it can also be done at the administrative unit level, starting at the city municipality, then within the province, and then finally at the national level. So setting a cap until there is none after 3 electoral cycles is also possible. We would also push for simultaneous and not just successive holding of positions. And we've seen the rise, again, as shown by the many studies, not only of thin dynasties, but also the worst effects of fat dynasties. And evidence from scientific studies shows, again, the inimical effect. And areas with more fat dynasties suffer from poor governance and socio-economic outcomes. In terms of implementation, we hope that, again, reinforcing what Chairperson Garcia from COMELEC earlier mentioned, in terms of implementation, administrative capacity, perhaps of COMELEC, can also be considered, and also voter education. This is from our study on the initial evaluation of the SK Reform Act, implementation of the SK Reform Act. So they have limited resources in terms of implementing and making sure that the enforcement of the anti-dynasty provision, the SK Reform Act, will be effective. And then in terms of voter education, our preliminary studies show that the limited awareness on the dynastic prohibition contained in the SK Reform Act is also, again, a challenge. It limits the empowerment of at least in the case of the SK, the youth electorate, not only in exercising their right to vote during the SK elections, but also in exacting accountability among the leaders and those who aspire to lead in the SK. So indeed, an informed electorate is a responsible electorate. So the proposed Anti-Political Dynasty Act or the bills, or probably the IRR, should include an awareness campaign or voter education program that includes not only the information on who are disqualified to run for elective office based on their political dynasty relations, but also the legal remedies to address possible violation of the anti-dynasty law. So again, we've shared our position paper, and thank you so much for this opportunity to share some of the points. Maraming salamat po.
Maraming salamat po, Professor, for your presentation. Before we proceed to the last two, last two. I'd like to first acknowledge my good friend from the 2nd District, Davao Oriental, Congressman Chino Almario, and from the 5th District of Iloilo, Congresswoman Binky April Tupas. Thank you, Your Honors, for joining us today. May we hear from Ms. Rochelle Porras, convener of Contradaya.
Yes, Mr. Chair. Thank you so much for giving us the time.
Can we be very brief na lang po sa presentation because we have a 3 p.m. session. Thank
Yes,
you.
we're very happy to be here considering na kami lang ang citizen-led watchdog and civil society organization na magsasalita today. So, thank you very much and I promise to make this quick, Mr. Chair. Para sa kaalaman ng lahat, ang kontradaya ay binubuo ng iba't ibang mga organisasyon kasama mga taong simbahan, abogado, IT experts, guro, kawani ng gobyerno, mga manggagawa, ordinaryong mamamayan po na nagkakaisang tutulan ang pandaraya at karahasan sa halalan at nagsusulong ng demokratikong halalan. Lalong mahalaga po para sa amin na magsalita ang isang citizen-led watchdog hinggil sa usapin ng anti-political dynasty law bill sa ngayon para maglinaw ng aming tindig dahil ang political dynasty ay direkta pong nagpapahina sa malaya at demokratikong eleksyon. Isa sa mga ugat ng pandaraya, abuso ng kapangyarihan, karahasan at pag-alis ng kapangyarihan sa mamamayan mula sa paghahalal ng tunay na kinatawan nila. The 20th Congress First Regular Session can make history by finally passing an anti-political dynasty law. Mahahalin tulad po ito noong 2001 and 2013 na sumubok ang ating mga mambabatas na maipasa ito. First point po, Mr. Chair, consistent with what is already stated in the pending 20 bills, political dynasty should indeed be defined in terms of familiar relations. Natutuwa po kami na dito pinag-aaralan natin kung hanggang saan ang definition sapagkat umabot na sa puntong pati significant others nagagamit pa para palusot sa batas para magpasa-pasa ng posisyon. Walang anti-dynasty law na nakakapagtakda ng ganoong definition o limitation kaya hindi rin ito nasasama sa statistics sa listahan ng political dynasty sa mga pinag-uusapan. Ganoon po talaga kalawak ang reality ng power dynamics sa usaping ito. It is so grave that it requires this kind of action. Nakakatuwang marinig ang mga pahayag na hanggang fourth consanguinity ay gusto nating isulong. Makakaasa po kayo na susuportahan namin to. Second point, Mr. Chair, we support and laud proposed provisions that dynasty succession should be disallowed. Ang isang government position ay hindi birthright. Ang isang tunay na batas kontra political dynasty, ang keyword po tunay o genuine, ay tinitiyak na hindi basta-basta at pasa-pasa lang ang titulo at posisyon sa pamahalaan. Ang dynasty succession may hahalin tulad po sa feudalism o monarchy dahil ang kapangyarihan ay pinapasa batay sa apelido, sa blood relations at hindi ito sa kakayanan o tunay na pagpili ng mamamayan. Taliwas po ito sa principles ng Democratic Republic. Ikatlo, second to the last point, hindi dapat tahimik ang ipapasang batas sa usapin po ng party list system. Sa research ng Kontradaya during the 2022 elections, halos 55 to 60% ng party list ang na-flag namin. That means 5 to 6 out of 10 party lists. Dahil sa lantarang koneksyon sa militar, malaking korporasyon, corruption cases, at pinakamalaki po sa percentage na yan, 40 party list ang may direktang connect, kinatawan at suportado ng political dynasties. Party list pa lamang po ito, hindi pa kasama ang political parties dominated and backed by political dynasties. Our empirical data indicates a need for clear provision banning political dynasties in the party list election cycles. Two main points po to emphasize this, Mr. Chair. Ang mga party list nominees una ay hindi dapat bahagi ng political dynasty at nasabi na ito kanina rin. Ikalawa, hindi rin dapat kinokontrol ng mga political dynasties ang party list sa likod ng eksena. Bawal po dapat ang placeholders or dummies as party list nominees as they operate behind the scenes. Panghuling point po namin, Mr. Chair, may position din po kami hinggil sa tanong kanina on appointment systems. Ang isang genuine anti-political dynasty law dapat ay nagbabawal din sa appointed system. That includes mga posisyon sa gabinete na hinihirang ng Pangulo para maiwasan din ang paglaganap ng dinastiya sa executive branch. While there are anti-nepotism provisions in our existing laws, something should be done to limit presidential powers given the need to prohibit political dynasties in senior government positions. Ang political dynasty, kapag ang kapangyarihan sa gobyerno ay paulit-ulit na pinapasa o napupunta sa ilang pamilya, direkta po itong konektado sa kung saan ginagamit ng mga opisyal na ito ang kanilang posisyon sa ahensya ng Estado para protektahan ang sariling negosyo at interes. Kaya po ang aming workers' constituency sa Kontradaya, hindi na rin po nagtataka bakit hirap na hirap kaming makapagpasa ng Living Wages Bill, ng Universal Social Protection Bill at iba pa dahil dominated originated ito ng political dynasties, mga families na may sariling interes sa kanilang businesses at iba pa. The point of the genuine law is to shift power to the people and communities and uphold democracy. Binibigyan din po ng kontradaya ang isang tunay, genuine na batas laban sa political dynasty at ito ang tutugon sa sistematikong pamamaraan kung paano umiiral at kumikilos ang mga political dynasties sa Pilipinas. Hinihikayat po namin, Mr. Chair, kayo at ang mga mambabatas na sana mabigyan pa po ng pagkakataon ng ibang watchdog at CSOs na makapaghatid ng kanilang points. Mga pangkomunidad na organisasyon na i-raise sa inyo ang kanilang mga naging suliranin challenges dahil po sa proliferation ng political dynasties. Panghuli po, hindi po biro ang ating sinusulong. Asahan natin na mahirap ito. We're going against the powers that be. Makakatuwang ninyo ang kontradaya sa loob at sa labas ng Kongreso hanggang sa aming mga members at chapters sa komunidad with respect to the four main points that we raise. Maraming salamat po.
Maraming salamat, kontradaya sa inyong posisyon. So, ang pinakahuli na po, the last but certainly not the least, ang aming suki, Lente, Attorney Rona Caritos. Ma'am,
Thank you, Chair.
Thank
you, Chair. Good afternoon, Chair. Good afternoon. Of course, we will support, Chair, but we will nuance our support to the proposed bills.
Okay,
Good afternoon,
Attorney.
Chair. Good afternoon to the honorable members of the House. Let me start with a quote from Attorney Christian S. Monsod, one of the framers of our Constitution. Political dynasties are inconsistent with the principle of equal access to opportunities for public service. When political power is monopolized by a few families, elections may still take place, but genuine choice and real competition are undermined. The constitutional prohibition is meant to prevent this concentration of power and to democratize access to public service. Grounded in this constitutional intent, Lente's proposal is different from all the bills filed and all the positions organizations have taken. Lente calls on our legislative institutions and relevant stakeholders to prioritize innovation and responsiveness in creating a mechanism which can effectively enforce the constitutional directive against political dynasties. The state policy declares equal access to opportunities for public service and prohibits political dynasties. Equal access to opportunities for public service directly pertains to electoral competitiveness and indirectly impacts public service. The prohibition against political dynasties is therefore not solely an electoral issue, but is part of a broader issue of effective public service. It is our position that this anti-dynasty provision is sui generis. And being sui generis, the prohibition stands higher at the legal framework, and it shall not be limited to undergo the usual processes that all of us are used to in the elections. As to the definition of political dynasty, we propose that it be defined as the running and occupation of family members in more than one position at the national level, more than one position at the provincial level, and more than one position at the municipal or city or barangay level. So after one electoral cycle, one family can occupy a maximum of 3 positions at the same time, one national, one provincial, and one municipal or city and or municipal level. As to the degree of consanguinity or affinity of family members, we propose to follow what is already provided in the SK Reform Law. Prohibition extends up to the second degree of consanguinity or affinity. As to the implementation mechanism, the primacy of the anti-dynasty provision as a constitutional directive should be controlling in relation to the grounds for disqualifications as enumerated under election laws. Thus, this direction requires an innovative approach to resolution by using a simplified administrative process, in contrast to the existing disqualification procedure under election laws. To aid the verification of marital and filial relationships, the birth and or marriage certificate of the candidate can be annexed to the certificate of candidacy or COC. Alternatively, an affidavit of marital and filial status must be executed by the candidate. The truthfulness of the information provided shall be warranted by the candidate subject to our criminal and election laws. At the end of each filing day, the COMELEC election officer will encode in a national, provincial, and city, municipal, and barangay database the contents of the birth and/or marriage certificates or the affidavit of marital and filial status of each candidate. At the end of the filing period, COMELEC will motu proprio resolve who among the family members running for the same position will be allowed to run. Within a set duration, the resolution can be done either through draw lots or voluntary agreement among the family members. Another way, aside from COMELEC resolving this situation on its own, is the filing of a request to verify and to resolve filial relations by any voter. Again, this request should not be considered similar to a complaint required by our election procedural laws. As part of due process, COMELEC shall be mandated to respond to the request by re-examining the birth and/or marriage certificate or the affidavit of marital and filial status submitted by the candidate. If the prohibited relationship exists, then the implementation mechanism of the Anti-Political Dynasty Directive will be triggered. Draw lots or voluntary agreement of the parties. Candidates who misrepresented should be charged with perjury with the accessory penalty of temporary disqualification from holding public office. In our opinion, this route will simplify the resolution of prohibited candidacies because it violates the anti-dynasty prohibition. At the same time, this would not unduly, and this would probably address the concerns of Chairman Garcia earlier, this would not unduly burden the dockets of COMELEC, which has been traditionally burdened by the usual electoral cases. Our proposal, of course, will raise eyebrows or will be asked certainly if it's constitutional. We believe it is, given that this anti-dynasty prohibition is sui generis, then it should not be treated as a qualification or a disqualification. Hence, it should not undergo the usual electoral processes. The proposed mechanism for the implementation of the constitutional directive against political dynasties deserves to be subjected to legislative and even judicial scrutiny, which it can ultimately stand. The perpetuation of power through family members has long been recognized as a practice to be prohibited for the purpose of allowing a broader voice in and improving public service for the Filipino people. Lente's proposal would give this constitutional directive, we believe, a more effective chance of implementation and truthful to the spirit of our 1987 Constitution. Thank you, Chair, for giving us this time and opportunity.
Maraming salamat, Attorney Rona, for the presentation. So we're now, I guess all of the resource persons, but sabihin ko lang before we end, I'm sure there are several questions that our members would like to ask. This is a continuing invitation, meaning if you're invited today, if you appear today, then the next succeeding hearings and meetings, we will be expecting you as well until we terminate the discussion on anti-political dynasty. So since we already heard the presentation of our guest, any members would like to ask questions, clarificatory questions?
Chair.
Yes, continue.
Chair, earlier I posed a question on whether the constitutional mandate to ban political dynasties applies only to elective positions. Since the wording is very clearly states political opportunities for public service, no? And I would just like to note and also express my thanks to Professor Garcia, who directly answered the question in his presentation that the committee should notice that yes, precisely the ban is or the mandate is to promote opportunities for public service, no? So that includes both elective and appointive positions, no? And very enlightening po yung sinabi niya that in the records of the CONCOM, the original wording was supposed to be public office. Pero nga, pinalitan, ginawang public service. No? So, I think, Mr. Chair, the committee should note that since nandito na tayo, ito yung pagkakataon para ipatupad, no, yung mandato ng provision na yan ng Constitution. Kailangang i-consider ng committee na ito that that mandate is intended to ban political dynasties in both elective as well as appointive positions. No? And I understand that this committee is a committee on suffrage and electoral reform. So obviously, mas ang
It's not within
sinasaklaw
our
niya
jurisdiction to
will be
discuss, yeah.
elections, pero that could all, you know, there could also be it could also be considered. For example, kung may kamag-anak kang appointed official, pwede ka ba tumakbo? If you have, you know, if there's a political dynasty relationship. So yun lang po, I would just like to note the answer and explanation given by the UP College of Law. Thank you po, Mr. Chair.
Thank you for that manifestation. It's well taken. Again, that's true. I agree with the Congressman Tino. The discussion revolves around the issue of appointive position. So the committee does not hold jurisdiction over matters pertaining to appointive. That's going to be a discussion on a separate committee, which I believe the Civil Service Committee. What we are discussing here is on the elective positions, which basically the very core intention of all these 20 bills submitted to this committee, which is banning family members from holding simultaneously public office within a certain degree of consanguinity and affinity. So, any other questions that members would like to ask our resource persons? Congressman Rodriguez, no questions?
All the presentations were very, very clear. So I have no question.
So if there are no other questions and perhaps no other matters, I would like to thank all the members present. I hope that you can also show the same commitment and passion and interest in the next couple of hearings that we will be holding. Yes, Congressman Kimbo.
The next meeting will be tomorrow, I understand, Mr. Chairman.
No, next meeting will be, I think, February 10. We're just securing.
I just wanted to express and support my deep interest as you required a commitment.
So what we can assure what we can assure the members is that we will be holding another committee hearing the same subject matter on February 10. I hope we can secure a big room such as this kasi marami pong magdaratingan po ng mga guests. So again, thank you very much for coming. Thank you to our guests for joining us. Sana po makabalik po kayo dito. May I solicit our favorite motion?
Move to suspend.
Yeah. So there's a motion to suspend the hearing on today. So any objection has been seconded. Again, thank you very much. Marami pong salamat. Keep safe. This hearing is hereby suspended. Assalamualaikum warahmatullahi taala wabarakatuh.
Kasi inuuna nila itong mga ganito resource person. Kasi dami rin naman. Saka yung